We're on?
Sticks with you, gets you through to breakfast.
Everybody ready? All right, good evening. Welcome to the April 14th Newmarket Planning Board meeting. Would you please join me in starting with the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Next on the agenda is public comments. Are there any public comments? Hearing none, I will close the public comment session at 7:01. Review and approval of minutes. The first set of minutes is of February 10th, 2015 minutes. Is there a motion?
So moved. Motion to approve.
Is there a second?
I'll second it.
Seconded. Any discussion? Comments? Any changes anybody would like to see? All right, hearing none, all those in favor signify by saying aye.
Aye.
Aye. All those? I'm going to abstain also.
I'm going to abstain because honestly, I completely forgot to read them. I apologize.
Okay. So 1, 2,
I'm abstaining.
you're abstaining?
I'm abstaining, I wasn't
You
here.
weren't here? All right, so it's 2-0. With 5 abstentions.
Got a lot of these first meetings.
Yeah, exactly, exactly.
First full meetings.
All right, next is the March 17th meeting minutes.
I'll make a motion to approve the minutes of March 17th, 2015.
Is there a second?
Second.
Seconded by Ezra. Any discussion?
I just wanted to, on page 9, line 22, Carrie Moorhead, Carrie just spells her name C-A-R-I, so just the...
Page 9,
922. C-A-R-I.
Mhm.
C-A-R-I. No E on
And
this.
there's no E in more.
And there's only one R, yep.
There's
It's
no
C-A-R, no, she spells her name C-A-R-I,
Right.
and then on Moorhead, it's M-O-O-R-H-E-A-D.
No E.
So no E.
Okay. Thank you.
Any other changes? Comments? Hearing none. All in favor, say aye.
Aye.
All those opposed, say nay.
I'll abstain.
And I will abstain also.
And I'll abstain.
So 4-0 with 3 abstentions. Onward we go. Next is election of a chairman. Do we have any nominees?
I nominate Eric Boderman to serve as chair.
I'll second.
Anything, anybody else?
No.
All those in favor, I guess?
Aye.
Those opposed? Thank you. Election of vice chair.
I'll nominate Dale Shelton.
Is there a second?
Second.
Second by Roseanne?
Rosie.
Yep.
Any other nominations? Hearing none. All in favor, say aye.
Aye.
All those opposed? Congratulations, Val.
Being Eric.
Appointment of alternates. We have an application, I guess it was received at the last meeting that I was not at, from Peter Nelson. I think probably all of us here know Peter, except, I don't know if you two know Peter. He was an alternate previously on the board. I don't see.
He's the one who was here last meeting.
Oh, he was at the
Yeah.
last meeting. Oh, okay,
Yeah, yeah,
okay. Okay. So he's applied for alternate position, which will expire in 2016.
I make a motion to accept Peter Nelson as an alternate on the planning board until March of 2017. 16.
16.
Second.
Any discussion? Hearing none, all in favor, say aye.
Aye.
Motion passes 7-0. So we will be sending Peter a letter, is that?
Yes, we will be.
And you will call him and let him know? Is that-
I will call him and let him know.
Thank you. Next is regular business. First is a public hearing. I guess we had to repost this. It's NIP Lot 6 LLC Shearwater Investment Corp. Public hearing for an application for major site plan review at 2 Forbes Road, NIP Lot 6 LLC, tax map R3, Lot 9-6, and 181 Exeter Road, Shearwater Investment Corp., tax map R3, Lot 8, both in the B2 zone. The proposal is for a 24,000 square foot expansion of the existing industrial building located at 2 Forbes Road with associated parking, drainage, and landscaping improvements. Pending site plan approval, the lots will be merged to make one lot. Is there anybody in the public out there who would like to speak to this application?
I'll be back.
Okay. We'll roll on without you. Alrighty, so there's no public comment. If anybody changes their mind, feel free, just raise your hand. We have in our package a memo from the town planner, but I would like to first hear from the TRC. I've missed the last couple of meetings, so would anybody in the TRC be able to just fill us and the public in on what's happened, where we are?
Well, we met, I missed the February TRC, so I can't speak for what
Yep.
happened in February, but we just met last week, and we went over.
Week before last.
Week before last.
April 1st.
Yeah, and they went over what, that the entranceway, that road is the town's responsibility. We cleared that up, and basically what you have in Diane's memo is what has gone on.
Okay.
Except for take off the excavation, because that wasn't talked about at the TRC meeting. But they have agreed to everything that we've asked to do. You know, with the buffering and
Yep.
whatever, so, I mean, they're,
And it's my understanding that the town's attorney has weighed in and said that the excavation is incidental to the development, which we had said at the meeting a year ago or whatever, right?
we didn't bring that up at the TRC meeting.
Oh, no. Does-
Do we have a copy of the letter from the attorney to that effect?
I don't, I read something, I thought it was mentioned that the town's attorney,
We had actually made a decision on that.
yes,
Planning at the May 13th, 2014 meeting.
Had a vote on it?
Correct.
yes.
That's in,
Okay.
that's in
Did
the
the-
development notes here.
Did the town, maybe I'm wrong, I thought I read something that the town's attorney, or maybe I missed, Diane will know.
The town's attorney letter was relative to what the planning board's decision-making authority
Oh, right.
Right,
over excavation versus development.
Okay.
If I'm wrong on that, the town's attorney
That's
did
why
not.
we had voted
Okay.
at that May 14th meeting.
And basically, he said that
The Donahue Tucker was March 17th, was the letter.
Right.
of
it was up to the
2014.
planning board to make a policy decision based on the facts and the information that was presented, which the planning board deliberated and did make a decision at that meeting.
So they didn't weigh in, they said we had the authority to make the decision we made.
Right.
Okay. All
So,
right, I
so
was
the planning
confused.
board, as regulators, has the
Yes.
authority for that vote?
Yes.
Right.
Okay. Now, if you could indulge me for 1 minute. At that meeting, Diane, you had mentioned that the planning board is the regulator in determining the needs of the planning board to consider whether or not it's an excavation or it's excavation to comply with a construction of a building.
Site plan.
In-
Site
They
plan.
call it excavation that's incidental to development.
To development.
Right.
And you also stated we have the authority to do that and the planning board has the authority to do that based on the facts presented to them.
Correct.
At that point, I believe that was only the second meeting after their application acceptance.
It was in
And
May, I believe.
It was in May 13th.
And I think we accepted the application as early as, I want to say, was it February? We maybe had a conceptual in February.
Right.
Yeah,
February, March. I remember.
Oh, go ahead,
But
go ahead, Bill.
Anyway,
regardless,
yeah.
it was
Right.
based on the facts
Yeah.
The 11th.
presented by the applicant to the planning board in order for them to make their decisions.
Yes.
And those facts are supposed to be presented by the applicant so that we can consider the scope of the excavation and the development, the impact to the area. And you read this from somewhere. I don't know if that's from the 155E.
It was from,
It's the DD, it's the Donahue Tucker letter.
it was the Donahue Tucker letter.
Okay.
And
App-
we asked the applicant, to address all those
Okay.
things.
But when that was done, and also it was the scope, it was the impact in the area, it was the overall intent, and it was the duration based on facts presented by the applicant. At that point, we did not even have a construction management plan, so the planning board did not know what was going on. We did not have any technical review committee meetings, so I don't know how the planning board could have made a decision, and that's just what it was. It was a decision. The planning board never had a vote to state that there was never a motion made or seconded in order to state that they are exempt from the excavation process.
The record reflects that it was a decision,
was
a
just-
it was a
consensus of the board.
Consensus, right.
There was one person, I believe, who was opposed, and
It
that
was
was
4 to
Dan
2,
Wright.
4 felt, well,
Okay.
3.5 actually, because John was kind of on the fence. But I don't know that, because the applicant, Joe Priscino, had mentioned that he was looking for an exemption, not an exception, from 105C in our site plan regs.
No, this doesn't have anything to do with 105-3C of the site plan regs.
Okay. But a vote was not taken, it was a straw poll, and I don't know if that's
No.
enough for a planning board to exempt someone like that.
Well, at the time...
I don't think it's an exemption, I think it's a decision.
It was a
made.
decision that the board made, and
Right.
But I thought a decision was a vote. Someone
it
makes a
doesn't have to
motion.
be a vote.
No, it could just be a consensus. But everything doesn't have to be by vote.
On something as important as that. I just would
That's-
think it would
I
have to be a
believe
vote.
that. I
The
believe that it was a-
consensus of the board without looking at the meeting minutes, but relative to this whole application, was that the excavation was incidental to the building, to the construction of this building. And there was certainly discussion that we would be able to tie in the, and I think you have it in your planning comments.
Yes.
Tie in the
The
vesting
excavation.
rights relative to a time period and what would be required in order to vest. Because the real concern was operating this as a gravel pit over several years and having that truck traffic constantly in and out.
Right.
In that they would only be selling it when the market was right to, as opposed to getting in there and preparing the site, which gravel would need to be excavated first in order to build the building.
Yeah. And I mean, it was an excavation site, from what I understand, years ago, so wouldn't this almost basically be under 155E, an expansion of gravel pits?
No,
No,
the only reason they're
the only
excavating
reason
is to put the
they're
building in.
building in.
Right. And that
Everything
comes
about the
under
site plan
plan
was
review.
relative to putting a building in.
If they weren't gonna do a building and they're just gonna do the excavation, I would agree with you, it's an excavation issue, but this is, they need to do the excavation to put the building in.
Now,
So-
what happens if they do the excavation and then they never do a building? Technically, according to your plan, they lose their vested rights. But isn't that a way of, in my mind, of circumventing?
It was based on the presentation, the facts that were presented, the information given by the applicant, the town attorney's letter that we did receive. We also had consultation with the Department of Revenue Administration. And based on all that information, the board felt comfortable, I guess, and with the
Yeah.
straw poll, if you want to call it that. And we did, at that point, acknowledge that to the developer, and he moved forward based on that assumption.
Well, yeah, I mean, personally, I'm not gonna sit here and assume that somebody's coming in here and lying to us about what they're gonna do. I mean, we could do that with any development.
Exactly, but the
So we have to take it on the facts that we're presented
I
with.
know, but what makes me think that, and makes me tend to go that way, is because there's more money, monetary value, in the materials that will be excavated as compared to what they could get when they do the building. So it's...
Whoa, how do you know that?
it-
I mean, are you a developer?
Does that-
Or a gravel pit
Does that
operator?
matter?
No, it's just,
I think, I'm not, I'd like to understand what's the point of that. If they have to excavate in order to construct a building, they can't construct a building unless they excavate first.
right.
So I don't understand.
But 100,000 square yards of I don't know what it's called, gravel or say materials. And maybe someone can answer this. Is Mr. Porterata's home and the house that they already obtained and knocked down, is that, those two parcels included in the 100,000 square yards or not?
And I think
That's a-
these
that's
No,
are,
they're not excavating that
Yeah.
far, they're stopping short of those properties.
and I think the applicant is here tonight, and you should ask that question of him.
I'm
Well,
just-
let's get through this first, because
Okay, and what kind of bonding will there be from the applicant in regards to, for DOT to do the,
DOT is out of the picture at this point. There's no
Right.
bonding from DOT. I am recommending that a performance bond be posted by the developer to assure, number one, compliance with the plan that has been approved by DOT, that they have a geotechnical engineer review and comment on, and that it be in the amount to cover the cost of reclaiming the site, to assure
Right.
that the vegetation is established. And we will ask the engineers, the applicant's engineer, to provide a cost estimate, which will be reviewed by the town's engineer to assure that's an adequate engineering cost estimate, and that will be used as the legal basis for the dollar amount of the bond. And if the board feels compelled, we can have the bond releases tied to a planning board approval.
and that's
To
for the
assure-
reclamation part of it,
Yes.
on the backside, on the slope?
Well, reclamation or bringing,
Stabilization.
stabilization is a better
Stabilization
word,
on the
yeah.
other side. Now, you said DOT is not in it right now, but because Forbes is a town-owned road, it is up to the planning board, well, the town, to apply for a permit for the
We've already
improvements.
applied for it.
We already applied for it.
And this, what we're recommending is that this plan, which we're going to discuss tonight, I hope, will become part of the Department of Transportation application, and it will be a condition of the approval of this development that the developer comply and implement that plan. And there
Now-
will be a bond that will be
So we-
posted to ensure that the road improvements get done according to the
So
plan.
there is a bond for that.
Excuse me, but just a point of order, because this has to be reposted.
No.
So It didn't.
It was posted last week.
it was
Okay.
reposted.
No, no,
Because
no,
it
no.
wasn't
Wait, Diane,
continued.
Diane. So is it considered a new application?
No,
Okay.
it's the same
All right.
application.
I
It
knew
was
there some
posted
discussion about
because
that.
it wasn't
I
correctly.
didn't know if we had to accept a new application
No.
first. Okay.
Because we didn't
Because
properly
we're getting into just a
continue
lot of
it.
discussion, that's
We
all.
didn't properly continue
Okay,
it.
So it just had to be re-noticed, sorry.
Right.
No.
Wrong term.
They're not.
Yeah, that's right.
Right.
And
And
so
we've done
Rosie,
that.
your
So-
question is the,
So we do have to have bonding for the improvements there.
We are I am
we don't have to have
recommending.
anything, we can decide what we want to have.
Right.
But-
And I'm recommending that there be a bond, not only for the off-site improvements within the public right-of-way, but there also be a bond to assure that the plan gets implemented according to what we have the geotechnical engineer saying, and also to make sure that the vegetation takes on the slope so that it's properly stabilized.
Now, because we're going to be, the town's going to be the applicant for the permit, DOT does not have its usual abilities to ensure performance, so it would fall on the town to ensure the performance of it.
That's the bond, yes.
That's the bond.
Yes.
Now, is the bond, who determines what the bond is?
The same thing.
And is the bond sufficient enough to do that? Because I know we had a thing on Fox.
Fox Hollow.
Run plant. Were you on
The way it works,
council then?
Roseanne.
I was, Fox Hollow.
Fox Hollow, and the town ended up having to pay
Right,
for
that's
improvements there.
different.
So do you have any idea how much of a bond?
And again, we go through the same process as we do for every project. We have a plan that's approved by the planning board.
Okay.
We give it to the applicant's engineer, and we ask his engineer to put together an engineering cost estimate.
Okay.
We take that engineering cost estimate to our town engineer to verify, to make sure it's accurate. We also have it reviewed by, as part of the town's legal counsel's review of the bond document.
Okay.
To assure that it's adequate.
Okay, and will those improvements have to be made prior to them starting the excavation there because of the condition of the road there on 108, especially with the development across the street with the 52
That's
homes.
up
It's
to
a
this
bad-
planning board if you want to make that a condition of approval, that's
You know, it's a
certainly.
bad section to begin with, and with so many trucks going in and out, hauling all that material out, I think for the safety, because 108's the only way in and out of Newmarket. I mean, if something happens there, we're in a lot of trouble. And it's a terrible road to traverse as it is. And to have all that traffic going in and out, moving all that material,
So,
I think, I would
That's up to
like
us to
to see.
decide.
So that would
We
be
can
a good-
Decide sequencing of the project.
Yeah,
that's a really
We can do
good
that.
suggestion, Roseanne. I think that could be worked into the motion for one of the conditions of approval.
okay.
If that's what you feel needs to be done, and the rest of the board agrees.
Anybody else have any
Diane,
comments or concerns?
Just one question, so just so I'm clear. When we talk about the bond and we talk about as it was proposed, we're talking about them removing the soil, okay, and then actually physically building the building. Is that
I'm
correct?
Well, the bond, what I'm recommending for a
Yeah.
bond is not to build the building.
Right.
It's to stabilize the slopes to assure that it meets the geotechnical
Yep.
plans that they have presented that have been reviewed by the geotechnical engineer, and to include his recommendations.
Specifically, number 3 in your planner's recommendation.
Yeah,
Yes.
right, yeah.
So,
Maybe it would be good, I think, for Diane to go through her
Okay.
recommendations.
recommendation, that would be good.
Yeah. I'd be happy to do that, and,
Don't know.
you have my copy?
No, but yeah, I'll give you mine.
What to do with mine?
Yeah. Yeah, I got another one.
I have also some materials I want to pass out to the board that came in this afternoon. And also, if you could make those available to the applicant, his engineer, that would be helpful. Mhm. Save one for me. Okay, you want me to just go over the recommendations at this
Yes,
point, Mr.
yes.
Chairman? Okay, I'd be happy to do that. Number 1,
Just one should be,
Just
yeah,
one.
then-
And then Jane,
Jane,
the
you wanna give-
applicant needs some.
Yeah, oh, sorry.
No problem, thank you.
All right.
Okay,
Onward.
very good. Item 1, the applicant shall enter into a developer's agreement with the town, which includes findings of fact, special site plan approval conditions, the town's expectations prior to and during construction, requirements prior to the issuance of building permits, certificates of occupancy, and scheduling. And I just want to mention that this is a standard clause that we include in all of our developments that are approved by the planning board, and it's a legal document that's signed by the chairman and signed by the applicant, and it is recorded with the plan at the Register of Deeds. And it includes things such as what Roseanne was just suggesting, the timing of the improvements with respect to various permits being issued. So if the planning board would like to include a additional condition to the effect of the road work has to be done before construction excavation starts, that we can make sure that that condition is included in the developer's agreement and will be carried through.
And also, is there a bond for the Forbes Road itself, for if there's any damage to Forbes Road from all the work being done?
That, I wasn't envisioning that, but usually that's up to the Public Works Director, and Mr. Graham
As long
has
as they're,
a
as long as they're
comment.
carrying legal weight and everything, we can't charge them if the roads get damaged. If they're overweight, that's a different story.
But we're not going to be there to check if it's overweight or not, so
Oh,
I
good.
think hasn't there been a precedent set that bond has been set on town-owned roads during construction, if there's any damage that the applicant's responsible for it?
I know some towns restrict it during
Some towns do, and
April,
it's a
you know,
good,
during
probably
March
a
and
good
April.
idea.
Yeah.
But I don't know of anything outside of that. But let's get through these
Okay,
before we
sure,
get
okay.
off track.
All right. Secondly, the applicant shall make advance payment to the town to allow for the town's engineering consultant to provide construction observation services, coordination services, to ensure compliance with the town's regulations and the approved site plans throughout construction. And the way we work this is we will ask, after the plans are approved, we will ask our review consulting engineer to tell us how much it will cost for them to be out there and doing site inspections at the periodic time that they need to be made. and to help us coordinate with the developer and his engineer on things such as the bonding and construction issues that may come up in coordination with the Public Works Department and the town's building official. And again, this is a standard requirement. The payment is requested in advance so that when the engineer's bills come in, we have the funds to pay them, and the costs are not absorbed by the town. Okay? Thirdly, the applicant's engineer shall provide a cost estimate for all off-site improvements that will be completed within the state's and town's right-of-way and within the site distance easement, and the on-site costs of reclaiming and reestablishing the stability of the slopes as shown on the plans and as recommended by the geotechnical engineer. Again, this is the basis, if you will, for the performance bond, and it shall be posted in an amount satisfactory to the town engineer, and the bond documents will be also approved by legal counsel to ensure timely and proper construction of the project. Any questions on that one?
Onward.
Okay.
Yep.
Again, that's a standard requirement when we have bonding for our projects. Fourth requirement, impact fees for the project calculated in accordance with the town's regulations shall be paid. In this case, there will be an impact fee for water usage, and we would have it be reviewed by the town's consultant to make sure the flow projections are correct, and that will be used as the basis of the water impact fee. And the applicant has the option to request a waiver from those fees, and there is a section in the ordinance that goes over what those conditions are, but that is an option that he may pursue. Okay, any questions
Any
on that
questions on
one?
that? Okay, Diane?
5, this, again, that's pretty much a standard condition on all our projects. Number 5, evidence that all federal and state permits relating to alteration of terrain and highway access have been secured. Copies of all permits shall be provided to the town prior to plan citing, and there's 2 applicable permits here. One they've already received from the Department of Environmental Services, an alteration of terrain permit. And the second one, which we've talked about, is the DOT highway access permit, which the town has applied for on the applicant's behalf. And these plans hopefully will be appended to that application and submitted for a final review by the state DOT. And we've been working very closely with the folks at the Division 6 of DOT on this project. So, you know, they've been partners with us throughout this process. Go
Any
ahead.
questions? Go ahead.
So basically, because these 2 permits, the alteration of terrain and the DOT highway access, the town is responsible for the latter. We have to have all permits accepted, secured,
Yes.
In
basically,
hand, right.
before we can sign. So before they can move a shovel of dirt down there, the town has to have the DOT
Right.
permit approved.
That's what we're saying.
Okay.
And before
Just to
Eric
be
will
clear.
sign off on the plans
Uh-huh.
and on the developer's agreement, that has to be in place.
Okay.
We don't have to do that. It's our decision that that's what we want to do.
These are recommended conditions of approval.
Right, but
To protect the town, this is
to
what we want
protect
to
the
see.
town, but I'm
Yeah.
sure some of them are pertinent to state and federal regulations and RSAs and ordinances that we were legally obligated to adhere to.
That's a different discussion, but,
Okay.
okay, yes, go ahead.
It's-
Any
again-
other questions?
Standard
No.
clause that we have
Yeah.
in all of our developers'
Okay.
agreements. Okay. Number 6, and this goes back to the intersection improvement plan, and I'm hoping we can have a presentation from the applicant's engineer on what we've come up with collectively with the TRC's involvement. But basically, we're asking that the applicant finalize that plan with the appropriate details as required by the review engineer, and that's what the second piece of correspondence that was distributed is about, and that it be part of that application, and that it will be the developer's responsibility to implement this plan as a condition of approval of the site plan application. Okay.
Okay, and we'll talk about the details of that after, once you go
Correct.
through the,
Yep.
through the list. Any questions on that? Okay.
Again, Diane, that's standard.
Well, this is a little bit different because it's off of a town road that's onto a state highway.
Yeah, but I guess what I'm saying, standard in the fact, if it was a town road off a state highway, those are things that we would anticipate being addressed.
That's right.
Okay, thank you.
Okay, the next,
And there's further details on that
Yep.
that
Yes,
haven't been read into the record.
correct.
which are discussed
Which
in
we'll
those
talk
two
about
memos
after.
that I've
Yeah.
provided you copies of.
How long will the applicant have to finalize the intersection improvement plan?
Under our regulations, conditional approvals are good for 6 months, so we expect that within a 6-month time period, the applicant will be able to comply with all the conditions. And sometimes there's an extenuating circumstance, and they can come back to the planning board and get a extension for another 6 months if they need it, for whatever reason. Okay, number 7, again, is a standard clause. What we basically want to see is any easements or deeds be recorded at the Rockingham Register of Deeds, and that those documents be reviewed and approved by the town's legal counsel prior to the plan signing. And in this particular case, and we'll talk about it further, there's some sightline easements that are being proposed across property which is currently privately owned but will be soon owned by the applicant. We understand there's an agreement on the property. But there's a sightline easement that will have to be recorded. And there's also some right-of-way changes that may result in a boundary adjustment that's part of the plan as well. You can show us what those are, Mr. Graham. But the legal documents that go along with those will be reviewed by legal counsel prior to the plan signing, and everything will be ready to go, so those documents can be recorded at the same time. Okay? Number 8, it has to do with vesting. And for our more veteran planning board members, you know that vesting is all about grandfathered rights. And there's there's an RSA that governs this in RSA 674-39. And basically, it says that the site plan approval will lapse after 24 months of approval unless active and substantial development has occurred.
You have 12 months.
And I'm asking that that be changed to 24, because there's been a change in the RSA.
Okay.
And what that does is, if active and substantial development occurs within that time, then there's temporary vesting for a 5-year period. And then there's this concept of permanent vesting, which occurs when there's substantial completion of the project. So as part of our due diligence and role, we need to establish when those events occur. So when does active and substantial development occur, and when does substantial development occur?
Any questions?
Go ahead.
Yep.
What, in this language, the final approval is when the conditions have been met? Or the vote in approval of the
for
actual application?
For purposes of vesting,
For purposes of this first sentence, the 24 months.
okay.
Is
This-
it, when you say final approval, what do you,
Okay, so in other words, if 24 months goes by and nothing happens,
so vote of the planning board?
then the site plan approval
So-
lapses, and that's in the RSA,
But
okay?
you're not.
But you're not
but it's a-
answering the question.
Right. Because we're granting a conditional approval, so it's not a final approval until the conditions have been met.
Oh, it's the conditional approval,
Okay.
sorry. And again, this comes out of the law, so I didn't write the law, but that's my understanding.
Question?
And-
Yes,
I think the RSA refers to approval. So we have to meet our conditions.
yeah, if,
for
once you
safe
meet your
vesting statute.
right.
Right.
So, you know, if
You
this
have
is
to
a...
meet the conditions.
We meet the
Right.
conditions so that we are actually approved.
So it's,
Under your rule, we have to do that within 6 months.
Right.
At that point,
Right.
the RSA of the
Kicks
24-month
in.
period begins.
Right,
So it's grant of approval.
so it's grant of approval.
Correct, because one of your conditions is, so let's
Yeah.
just use the DOT permit, for example. If we haven't received the permit from DOT, we can't
Right.
start doing anything.
Right.
Right, right.
So
And there's
they-
some new language that's been added to the RSA that talks about, you know, if there are outstanding permits that haven't been issued under extenuating circumstances, this can be amended, blah, blah, blah. So I didn't want to get into the finer nuances of the law, but,
Okay. Then my second.
and this, again, is going to be, the language is going to be in the developer's agreement, and that will be reviewed by John Radigan's office to make
Okay.
sure that it's the correct legalese.
You had another
But we also
question.
want to make sure that the conditions that the planning board, the language of the conditions is what the planning board is voting on.
Yes.
So my second question is, when we're speaking of active and substantial development or building, which is how you currently have it as the recommendation, can this be modified unless active and substantial construction of the building has commenced?
You, I guess you could do that. And that's what we need to discuss, I
I have.
think.
We-
We need to,
We need to
That's the plan
define what
gonna get
that
to.
is.
Right.
You can't modify
I
the state
didn't,
statute.
that's why I was asking,
No.
was that a?
Well-
what's
Is that part of the statute?
It
Can I
is.
borrow this?
That language?
Active and
Verbatim.
substantial,
yeah, I have a
Development.
copy of
Okay.
it right here.
It doesn't even talk about building, right?
It's a state RSA.
Right, okay.
But it's.
Go ahead, Roseanne.
It's a state RSA, but cannot the town modify their ordinances in using state RSAs
Radigan is proposing.
as long as they're more stringent and less, and not less?
What, if we don't have it in our current regulations, we can't?
Right.
Well, we can make, we can basically make any condition we want.
Right.
Within our regulations?
Within our regulations.
What I
right.
Okay.
have given the chairman is the most current language that the town attorney has recommended to be included in our developers agreement, which is based on the
674.
current RSA, because it has been changed and modified. And this was from the golf course project, but there have been changes
Yeah, and I mean,
to
he
it.
has final approval in here, but there's other language in here that he doesn't have in, that we don't have in here.
Right. This supersede, this is the actual language that will be in the developers agreement. This is the
Yeah.
planner's interpretation of the language.
Yeah, okay.
But it also,
yeah.
but if you read the last paragraph, paragraph 4, it says failure of the planning board to specify by regulation, which we discussed that we basically don't, or as a condition of division plat, a site plan approval, which is what we're going to
Which is why I'm
do,
asking you to do that.
shall constitute, so we do have the authority to state what is
Right.
active
yeah.
and substantial development.
Yes.
Yes.
Oh, yeah.
Okay.
And
Yeah.
that's what I'm recommending, that you need to do that as part of your
Oh, yeah,
conditions, so that
but
it's clear.
It is, it's or in accordance with the terms of the approval.
Right.
It's
So
also
we need
within
to
that paragraph.
define that. And it should be a, a second step that we go through every time we do a major project. So it's clear when that happens.
Yeah. And I think basically on number 8, it would be good to have, once everything's and everything's done and the 6 months have passed and we've got everything going, from time that they're allowed to, that we set a 2-year limit also on number 8, that they have their excavation completed within 2 years.
Well, let's talk about that after. Let's go through these, and we
Okay.
can discuss any particulars, but,
So,
yeah.
Yeah.
the other thing I'm struggling with, is it 6 and then 24?
No.
Well,
6 months to
They
comply.
have to,
It's, once they have their approvals.
Right,
Whatever date that is, the
Right.
24 months kicks in.
right.
It could be 6 months, it could
vesting.
be a year if the state takes forever to give
Right.
them the highway access
Understood,
permit.
understood. But where am I getting the 6 months from?
that's from our local regulations that says
All
the
conditions.
applicant has 6 months to address all of these conditions.
Right.
So the
Right.
plans can be signed by the chairman and
Right.
recorded.
So I guess what I'm saying, cradle to grave, it's really 30 months. But to your point, the actual action plan is 24.
Right.
I just want to make sure I understood
Yes.
where the 6 was before, during, or after. Okay, thank you.
Are you all set for now, Val?
Yep, I've got the language right here.
Okay.
Okay, and item 9 of my recommendations is that the appropriate paperwork be filed with the planning department so that the merger of the lots can take place and that's just putting together a deed description, and the planning board can authorize the chair to sign it, and then it can be recorded. It's not a big deal. We can do that at the next meeting if you'd like us, if the board approves it this evening. It's up to you. And I have one other recommendation, and that has to do with some follow-up recommendations that have come from the town engineer and from our public works director.
Oh, is that what you just handed out?
That's what I just handed out. The TRC did meet on this last Tuesday. We had a very productive meeting, and I think everybody was in agreement with the plans that had been submitted with a few minor modifications. Unfortunately, Rick Molaski was unable to attend that meeting. He had a funeral to attend. However, and several of these comments that came from the state were directed to the Public Works Director. So Rick Molaski met with Phil McDonald on Friday, and they walked the site, and they had a few additional technical requirements that needed to be addressed. And if you follow the line of the chain of the emails here, there's an email from Phil McDonald dated April 3rd.
And Phil McDonald is
the town engineer with Underwood Engineers.
Yep.
Yep. And they're recommending that a catch basin be added to the northerly side of the Forbes Road intersection along the curb line, and that be tied into the existing catch basin. And they have attached a plan with some red marks and notations that illustrate what they're talking about or what the recommendation is. The second recommendation, that there be a drainage manhole cover installed to replace the existing catch basin frame and grate. And the third recommendation is that a pavement overlay be provided to the limits of the work, again, as shown on the plan. And following my receiving this from Phil, I followed up with Rick Molaski to make sure he was on board. And I have a follow-up email from him dated this afternoon at 5:36, saying that he did meet with Phil, he agreed with the recommendations, he feels that these improvements are necessary and that the cost should be incurred by the developer. And so it would be my recommendation that we add a 10th condition that prior to the submission of the package to the State Department of Transportation, that these further recommendations be incorporated into the plans and be forwarded to the state with the rest of the materials so that the state can issue the highway access permit for the project.
Can I ask a question?
Sure.
Does that still not fall under item 6?
It's
Which
related
is
to
finalizing the
6.
section improvement
Yeah.
plan,
Yeah, if you wanted to put that,
if that's,
yeah,
6
tie it
AB.
into 6, so we only have 9
And-
conditions, that will
well,
simplify things.
I was gonna ask, as we go back now and if there's any questions, I was gonna ask the applicant if they could, briefly, especially for the people at home, walk us through what the improvements are proposed at the intersection. I don't know if you have a plan of that or not, probably not, but if
Yeah,
you
they
could
do
just.
have a
Oh, you do have a plan of that
Do you want me
tonight?
Sure, I can break out the plan. There's also a plan that I believe was handed out to everyone in their packets.
There was a 11 by 17.
Yeah, exactly,
Did you all
that should
get
work, so you
that?
kind of follow
No?
along.
Sue Jordan put it in everyone's mailbox.
Get it, yep.
Yep.
Before you start, Joe, I just have to say something. Mr. Chairman, my name's Robert Graham. I represent NIP6 and Shearwater Investments.
Welcome.
Thank you. I think we applied back in December of 2013. I think our first hearings were in January. We've been at this quite a while. We've strived very diligently to address adeptly and thoroughly every concern this board's had. We've acquired real estate to the extent of about $500,000. Our design fees are more money than the material that Ms. Roseanne Quacks believes is worth so much money. And we're here to develop real estate in Newmarket and make an investment. We own the Bank of America, the former Bank of America. We've just renovated that. We think that's a good addition to Newmarket. We're here to make an investment in Newmarket. We're here to put our best foot forwards and work through these things with the board. And I just feel, I sense a sense of hostility that I really don't understand where that's coming from after the effort that we've put in. So we're here for a fair proceeding, and we've always gotten that from the board, and I don't mean to say that we haven't. And we'd like to make a review and answer any questions that we can, and then get to some action this evening. We do have a couple of minor additions to Diane's comments, which I think are pretty thorough, complete, and good, and address most of the issues that we're talking about this evening.
And you agree with those for the most part?
For the most part, yeah, but there's just a
Okay.
couple of adjustments in terms of times and scheduling, which I'm sure are going to be a work in progress anyway. But I'll turn over to Joe now, and he can give an update of what we worked through with the Department of Transportation.
Sure.
And then we can come back to those conditions.
Yep, absolutely.
Thanks, Rob. So, again, I'm Joe Persino from Ty and Bond. I'm the applicant's design engineer. For the members of the planning board that are newer, you may have not seen me, but we have been here for over a year and a half with this project. So, the one last outstanding item that we had, which I believe we updated everyone back in January, Mr. Chair, I don't know if you were here at that meeting, but we updated the folks saying that we're still working on this project with the DOT to get the intersection improvements that were beneficial to the town. And this is what we came up with. It's pretty basic. I'll just go through it real quick. If anybody has any questions, we can surely answer them. You should have a plan in front of you that is really just a smaller version of this plan to follow along. But the concern was that the visibility on the right turn out of Forbes Road was being impacted by the vegetation located on the Blackadar property.
Sorry, I know we have our own copy, so I don't know if maybe that can be moved over, so if other folks want to be able to see, they can
Sure.
also see it.
If you
Where's the camera?
however you want me to do it.
The camera usually keeps it up there.
Yeah.
Is the camera right here?
Yeah, okay.
So we'll leave it.
So for the folks at home, it might be beneficial.
Okay.
Yeah.
And then if
Yeah.
anybody from
That's
the
fine.
audience would like to come
So
up,
if anyone
take a
wants
look,
to borrow a
I
copy,
can
I can-
spin it around or
Okay.
answer questions either way. So, so the right turn out of here, now what will be taking place is the vegetation will be removed, and this is being made possible by the developer's ability to purchase that property. So it wasn't something we could do before, and that's why it kind of took us so long to get to this point, because that one piece had to be, pulled into the puzzle to make this all fit together. So the vegetation will be removed. There'll be a permanent easement that will be in benefit of the town of Newmarket. Since it's a town road, the town will have the ability to clear that vegetation or make improvements to that for visibility. So if something, snow or whatnot gets pushed in there, they can get rid of it. Then we have also widened the radius. So the turning movements out of that road on the right-hand turn for truck traffic will now be able to make that turn. WB50 will be able to make that turn without going into Route 108, the southbound traffic. So basically, we widen it so now that truck movement is unhindered. So those are the improvements. In addition, there are the improvements that Phil McDonald from Underwood Engineers, the town's engineer, has recommended. We just received those plans, or those comments, excuse me, this afternoon, so we haven't had a chance to incorporate them. But as you heard, we will incorporate them as part of this plan prior to approval.
So, so the widening you're doing here
Mm-hmm.
is because the existing roadway, as it is now, trucks have to go into the other lane to get?
Yeah, basically the truck turning movements, they have to kind of go out and into the southbound traffic lane of Route 108 before taking, before heading north.
Okay.
So now with that radius pulled back, they can stay in that lane and they don't have to wait for a break in traffic.
Right, so this is an existing condition you're taking.
This
you're
is an existing
improving.
condition.
That is not any fault of
That we're
yours.
improving, none of these
Right.
None of these improvements address anything that is being caused by the applicant's building addition. These are all existing issues that, the applicant has decided to improve as kind of a benefit to the town.
Okay, so I think I heard you say that you're okay with the revisions that Phil and Rick Malasky agreed to. Basically extending the catch basin over to the side, putting a
That's
manhole
correct.
cover on the catch basin and resurfacing that small area.
That's
Right.
correct.
Okay,
Just like to just address the timing of those?
Sure.
okay. We can talk about that. Does anybody have any questions to what you've seen here, what's presented? Go ahead, Rosie.
There was a question, I remember reading a memo before about impact to the bike route along that section. Is it on that same side, or what's going on with that?
We're looking at, we're going to be actually having a public hearing coming up in May 20th. It's scheduled for the town council meeting, and Underwood Engineers is going to come and present the results of their preliminary engineering study that they've done. They've worked up some cost estimates, and they've worked up some plans. We have heard from the state there might be some additional money that might be provided to the town, so the town can go forward. But at this point, they're talking about widening the shoulders, and then there would be a small portion of an off-road bicycle lane that would go parallel, if you will, with the golf course property, kind of meander in between the trees and the tree line buffer. And again, all those ideas are going to be reviewed, and we'll be seeking public input and some, feedback from the town council on whether to move forward with that or not. So the short answer to your question is yes, they have coordinated with Underwood Engineers on the Route 108 shoulder widening bikeway project.
We paid for quite a bit of preliminary plans for that, and we did a lot of survey work.
They did.
Right.
And initially, there was thoughts that there might be, the need for some additional right-of-way on either side of Route 108 in order to do the project. And we ended up modifying the plan accordingly. There was a recommendation that there be a center turning lane installed in order to make the traffic flows better through that area, but that was really outside the scope of both their project and the town's project, but it's something that could be considered in the future, and they did do some conceptual engineering so that we could move forward with that at some later date.
So to answer Roseanne's question, though, there's no impact to the bike
No.
lane project?
And is the state requiring us to put bike lanes there?
They're not
We're not
requiring
obligated,
anything.
okay.
They've given us almost $1 million for a project to either widen or provide some kind of means for bicycle travel.
Okay.
And the actual solution to that problem hasn't really been worked out
And that's
yet.
just in that area there?
The study area is from Bennett Way all the way to the Newfields, basically the Newfields town line, and before the bridge.
And is $1 million enough for the town?
Well,
Maybe
is the
not.
town
We don't
going
know.
to-
Let's
That's
not,
a
let's
good-
get on
That's part of this
different stories.
application.
Yeah, let's get on
And
different.
that's why we had to scale the plan back, because there
Okay.
wasn't enough money.
All right.
So I'm hearing that you're in concurrence with the plan that we have, your plan with the amendments made. I think everybody up here is okay with this. This has gone through, and basically, I think we're a bunch of town recommendations anyways. Go ahead, Ezra.
So I was just wondering, on condition number 6, where it says the applicant shall finalize the intersection improvement
Yes.
plan, so what still needs to be finalized?
It needs to go, an amended plan needs to go to New Hampshire DOT for the access permit. That's it.
So the plan that they have here needs to be modified to address and include the recommendations that Phil and Rick had put together.
Okay.
And once that's finalized, then it can go to the Department of Transportation, and they'll review it, and there'll be a highway access permit
Okay.
granted to the town to allow the project to go forward.
So we can kind of lay this one to rest. You had some concerns about timing. What's your thoughts on timing?
Well, we'd like to time like work with the construction of like work in the project. So ordinarily, these types of improvements are subject to rational nexus or fair sharing under the state statute. We're taking a look at those, and Diane and I had spoken about them this afternoon. And again, we haven't had a lot of time to look at these, but I've spoken with my client about it, and we're willing to do 100% of those drainage improvements, which are improvements to the town's drainage infrastructure.
Yep.
But we want to do them when we're doing our drainage work and constructing our site. We don't want to go mobilize crews twice for all that stuff. It's very expensive stuff to do. So from a sequencing standpoint, and we can work these out in some of the construction management plan, but I want to make sure that we discuss it here with this board, because I hear a lot of direction coming from how we want to handle some of these, and I want to just interject some of the realities of the construction sequences. We've just closed on the purchase of the Blackadar property, which is the property that on your plan is the property where you see the radius expanding. So part of the finalization plan for, there's kind of two phases to this DOT finalization plan. You have the finalization, which are a set of plans, but we have to make a lot line adjustment plan and grant easements. So we're going to grant land and easements, which are both mitigation under the DOT highway mitigation rules. We're going to do that first. We're going to do the clearing of the trees and the brush, which are the sightline distance issues, because we believe they should be done immediately. There are safety aspect issues out there. We have the ability to do those right away, and they're relatively low cost. We would like to do the expansion of the pavement radius and the drainage work in one construction sequence when we're doing our other drainage and pavement work. Those are the same crews. And it makes sense to do those after we're well through our construction sequence. So we just like to make sure that those are done prior to our occupancy permit.
So it wouldn't be done prior to moving gravel off-site?
The drainage and pavement work would not be done. The granting of the land and the site easements would be done, and they would all be bonded. We would bond up front.
Right.
So, and what
The
is,
size of the trucks coming off the site from excavation aren't the really big ones that's causing the problem now, correct? Would the size of those trucks actually be using the northbound or southbound turning lane? Or
No, they'd be going the
run
other
108
direction.
lane?
Primarily, they'd be going the other direction to head up to 101.
Southbound?
I meant,
Yes.
southbound.
Southbound
This,
going,
this
by
work
that
is
you
being
mean
done on the
down
northbound,
there.
and the
Right.
problem now is the
Gotcha.
large trucks
I
are
hear you.
going into the southbound lane.
okay.
And this is just so that, just to recap a couple of things, because these are really, and it's hard, I know that it's hard to keep up as a board from the standpoint, there's a lot of meetings that happen in between, and so there's an evolution of some of these things. This plan change here is a combination of a couple things. It allows the radius to work for the truck movement. The primary truck movement out of the industrial park is a left-hand movement, but this should be accommodated for, but probably the more important reason here is that this allows somebody that's pulling up to turn right, to pull up, to move to the right, and actually to have a better view of the distance down the street, and to have the car pronated properly versus I'd say that's, give you an idea, there are 50, or I'm sorry, how many units are out back in those apartments?
The condos down?
Yeah,
This is 20?
No, there's
No.
25 or...
Yeah.
Oh, you're talking, I thought you meant
Condos.
Needle Lane, I'm sorry.
No.
Yeah, there's probably 25, 30 maybe.
Yeah.
Okay, so if you look at the trip generation, there's far more cars leaving this site in the morning than there are industrial vehicles leaving the site in the morning. That's just the opposite trip. So that's a twofold reason there. But the most important issue out here is this sightline aspect, and the radius. The correction to the radius in the DOT conversation was, that discussion was even prior to the fact that we now own this piece of land. They can cut all the trees.
Yeah.
Which is great. We were very
So-
pleased with that development,
Yeah, and-
needless to say.
I guess for the record, personally, I have no problem with what you're suggesting. I think those issues will be addressed by the New Hampshire DOT in their permit.
Okay,
And, I mean,
great.
it's their road.
Yep.
If they're okay with that, I certainly understand what you're saying. I think it does make sense to do that at one time. But I don't want to speak for the whole board. I want everybody to weigh in on that.
well, I was just wondering, I mean, you were asking us to add language in about certificate of occupancy. If we didn't change any language, is there a requirement about when the timing that it has to happen by? or-
Conventionally, by a DOT permit is by occupancy.
Right.
So, okay,
And
so
the
you're
town
not,
has the same policy
And that's a
as
town
well.
standard as
so
well.
you're just clarifying for us kind of what you're hoping to do, but you're not asking for us to take any action per se on that, or?
We
I
just
think
want
what-
to understand what the timing is going to be.
Okay.
I want the board to understand what it is, because Roseanne raised the issue earlier that she wanted to
The
talk about
municipal.
having all the improvements done before construction started, and that's just not typical of how the sequences work. So I don't want to leave it to the minutes without us discussing it directly.
Okay. Well, thank you for the clarity then.
Sure.
But, Janice, you have any concerns about what he's...
No, I just have a question, because you said you just
closed?
purchased the deal and closed the
This
deal,
house.
piece of property. Is that the property that, if you look under the memo that Diane just sent out, it says future considerations?
Yes.
So maybe that
from-
could be looked at and,
From Phil McDonald.
yeah.
Actually, no, that's this house.
He's talking about the other radius. at
He's
some
talking
other
about
date.
the house on this side of the
Okay,
intersection.
sorry, there's a lot of little
South
houses
I don't know if
there.
you can, I don't know if you can actually see that, the opposite side of the street. There's a house lot here.
Okay,
If you're coming out of the road, the house on the right is the one we purchased because the concerns at DOT were this sightline visibility and this radius.
so he's talking about a different house. Okay,
In
all
the
right.
future, this may need to be addressed.
Okay,
Right, but
And
we're
I-
not
It's not this
expecting
one,
anything
okay.
as part of this project.
Right.
Okay, but just so I'm clear, you just want this discussion in the minutes so that it's clear when you do the sequencing in the developer's agreement that this is how it will occur and that the board is okay with that.
Correct.
And the sequencing was something about the water structures,
No, yes, the sightline work was gonna be done,
sightline, okay.
which is the major issue that DOT
The
had.
trees, I have
Then
the-
the widening and the two drainage structures, the catch basin adding and the changing the catch basin to a manhole will be done at the time they do the rest of that similar work on site.
And the pavement overlay,
And
because
the
they're
pavement
asking,
overlay.
they're asking us to
Yes.
overlay the pavement in this whole area.
Yes,
Right.
So clearly we want to do that after we're done.
yeah. So when you have doing the drainage on site, they come and do this.
We
Right.
want
I
to
mean,
consolidate the
right.
work for
But,
economies of
but
scale.
is he asking not to have to do that until they have an occupancy permit of just prior to?
Correct.
He can't get an occupancy permit until he has that done.
Right.
But,
And that's the leverage
Right.
we've always had.
Because there won't be a new trip generated by the
Because-
permit until that happens.
Right.
And technically, he doesn't need site plan approval until he's ready to occupy the building.
Does it need site plan approval?
No.
Compliance.
I don't think what you meant.
Compliance.
I mean,
Yeah.
compliance with the
Compliance.
site plan
Right.
until they're ready to, I mean, the occupancy permit is the leverage that we have to make sure that the plan has been implemented.
It will be bonded up
So
front.
before we issue a certificate of occupancy, we make sure that all the site work is done and it's been done according to the plan. And at that point, we can release the bond and we can issue a certificate of occupancy, and basically they can move in their lease C.
Right, and my take on it, my personal take on it is that they have agreed to undertake significant improvements to that intersection that really isn't their responsibility.
Yeah, it's an off-site
It's a
improvement.
town road, and it's not, it doesn't comply now. I think what you've agreed to is fabulous, because I know a lot of people would not agree to that. So,
And we believe we have an obligation as a fair share aspect there. And we understand the complexities of this kind of work in towns and budgets and all that kind of
yeah.
thing.
So
We
I
just-
think the timing, I'm personally okay with the timing. I think that's
I am too.
reasonable.
Yeah. I
And if the
understand
building
that.
doesn't get built, we are holding the bond to complete this
Right,
work.
correct,
okay,
correct.
all right,
Correct. Right.
And it's to his interest to get it all done,
all right.
and to release the bond.
Okay, so let's go to, the other one we wanted to discuss, the item is item 8, which is dealing with the vesting. So the first change we made was that it went to 24 months, which is the statute, you said.
And the
Right.
statute is 24 months after the date of approval.
Approval, right,
So take out final.
right.
You're going to take out the grant of final.
Just say the
After
date.
the date of approval.
That's the statute,
Okay.
after
All
the
right,
date of
that's good.
approval.
And
after the
conditional
date,
approval
that's-
is not
that's good,
considered
Val.
an approval, it is approval,
Right.
when all conditions are met on the,
And appeals.
right.
Right. The planning board is the one that can determine what we will constitute active and substantial development or building.
Correct.
And-
Correct.
Okay?
Correct.
So I think the discussion that the board was leading to earlier over this is relative to substantial construction of the, and I'm putting in here, exterior of the building shall constitute active and substantial development or building. So we're defining that what is active and substantial would be a substantial completion of the exterior of the building.
Okay, there's two definitions. There's active and
It's
substantial
all
development.
one under the RSA.
And then the second is substantial completion of the building.
Well,
Does it say,
active and substantial development or building is the RSA, in
Right.
parentheses. The planning board has the right to determine what constitutes, again, in quotes, I should say, active and substantial development or
Correct.
building. I'm recommending that
okay,
the planning board determine as to what constitutes that, being substantial construction of the exterior of the building. So we have the right to define what that is within, as under the time period per the RSA, or how I understand the RSA.
Could I add to that?
Sure.
So, really, there's a ladder that occurs in the active and substantial, the substantial completion, and then vesting.
Yes.
And vesting is really where the jurisdiction of the board takes place in terms of the latitude of the board to say, this is substantially complete. Active and substantial has been settled by the courts in a lot of different ways, and it's really left to the RSA, and that's why the time schedule is built in time, the statutory period of, you have the first active and substantial period, which is active and substantial work that is positive, significant investment according to the site plan approval towards the finished product, towards substantial completion.
Right.
Active and substantial is not vesting.
Right.
Active and substantial is a start.
Right.
It's temporary vesting rights.
Exactly. And that's under the site plan review statute.
Right.
So that's not a statute that this board can modify.
Correct.
And I'm
The
not
stat-
proposing that.
So now, clearly, if a building was started, yes, you would have active and substantial completion, and the statute uses both of those terminologies to cover aspects of site development and building construction. So you may have a site that has an approval that didn't require site work, but you could start building a building, in which case, building a building would be active and substantial. But in a site that requires a lot of other work before you get to the building, you could have active and substantial long before you have substantial completion or the structure of a building. So the idea that you would elevate the requirement of active and substantial from a start to the construction of a building is burdensome, goes way beyond the RSA of the state of New Hampshire. So, and I'm not saying that there may not be times where that might be relevant, but in this case, this site is clearly in the jurisdiction of, there is an extensive amount of site work to do. There's time that is allotted by the state statute to do it. We are allowed to climb that ladder of a start of work, a substantial completion of that work, and the vesting aspect, all that means is that it vests us. It doesn't mean that we have to have the work done by then, or we have to occupy then. All that means is that we are now immune from new legislation of the city or the town.
Right.
So those are not burdens on us to complete by any period of time. They're a timeline in which we're allowed a safe harbor from new regulation. So I want to make that distinction clear, because that's what's important about when you talk about these timelines. These are not requirements for us to do anything. They are a shield or a safety mechanism to protect us in our due process rights by what is adjudicated in the board and what we've paid and invested in and relied on the board's jurisdiction.
What is your projected time frame for when you think things will be constructed to whatever degree?
No, I agree.
Well,
I'm just
we would start,
saying
we're going to start immediately.
under the RSA.
And we will start immediately, and we have a pretty decent-sized amount of material to move. There are other aspects to this site. I would expect that we have a solid year and potentially two to get the material out, get the site stabilized, and get to what we call pad ready. And so we could get to pad ready, and we could sit there for a year. We're still we still have completed our active and substantial, and by most court precedent, we're substantially complete from the site requirement. So we've invested enough money at that point for the size building, the things that the site plan regulation regulates, drainage, traffic, all those things. If we substantially completed the issues that are relevant, for example, completed our traffic work, brought the site and installed drainage structures, finished got into our grade elevations and stabilized the site, then we have the right to the next ladder in that vesting statute.
Right, but isn't it in everybody's best interest for us to define what active and substantial is, so that there is no confusion if
It's clear in
things
the
don't go as
RSA.
per plan?
Right, and we were
So we all understand, and you understand, and we have a discussion on what we agreed to as active and substantial? We're not saying it has to be done, you have to start, right?
Correct. It is a start, and the state RSAs do address what that is, and the court precedent's very clear. Active and substantial can be clearing and grading. Active and substantial actually in the court can be full architectural plans submitted for review to the town under the ordinances of the town.
But it's up to the planning board to determine what that is.
Yeah, it
Yeah.
clearly states that
Yes.
under section
Right.
3.
That's what I read.
That's what I'm
It's
getting
up
at.
to the planning board to determine that, relative to site plan approval. It's up to the planning board to specify the threshold levels of work that shall constitute the following terms with due regard to the scope and details of a particular project. A is substantial completion of the improvements as shown on the subdivision plat or site plan for purposes of filling per paragraph 2, which is what you're referring to relative to vesting, and active and substantial development of building for the purposes of fulfilling paragraph 1, which is the 24 months. And it's clearly under section 3. We also have the ability to extend the 24-month paragraph for good cause.
Right.
Is there a main concern that I'm missing though? Because it's, I mean, my understanding of the whole issue of Vesidis is that from the town's side, we don't want 3 years to go by, nothing to be done, and then we to have better regulations that apply and changes have happened, and then have the plan that we approved now be the plan that's built, and on the other, so that's the town side, and then your side, but that's not what we're discussing.
Yeah, but that's actually not the goal of the statute. The statute,
Well,
this
on both
statute
sides,
protects the
it's town
applicant.
and no, I'm saying that it's on both sides, right? So
Against
that
changes in the zoning.
This
Right.
has nothing to do with protecting the town of Newmarket.
Right.
This protects us.
right.
And I would assert that the issue, that the assessment of whether or not it has taken place takes place at the time that that period expires. And based on those approved plans, yes. If what it's talking about is, if the rule has changed. Now, if the rule has changed, this is moot. If the rule has not changed, this is all moot.
Right.
If the rule has changed, for example, next year you guys change the maximum building size or the zoning requirement in that town, and we get to the 24-month period. At that point, if we've done nothing,
You lose your right.
correct, and so you are not obligated to issue us more permits, we don't have the right to continue moving on.
Right.
It doesn't mean that we have to flesh out what exactly those requirements are here today. That's not what the statute is designed to do. It puts us on notice. The board's going to get to determine at the 24-month period, if we haven't done something active and substantial based on what was approved, then the board gets to determine, are we subject to or not subject to the new regulation? That's all.
Right.
This is not a deadline, it's not a finish line, and it's not a requirement for construction.
It's for vesting.
It's
vested
protection
law.
for us.
Right.
But we're still.
This is a
required-
limiting of the town's authority, not an expansion of it.
Right.
But it still is allowing the planning board to define what that threshold is.
Right.
It's
And
very
there's no
clear
question that the
in
planning
the
board needs to
statute.
do that.
At the 24-month period.
Right.
Right.
And I think you've had
It's
a
only practical.
suggestion of what that should be. I don't,
No, it's as a condition of the subdivision plat or site plan approval, what
Right.
shall constitute under section 4. So it is at the time of site plan approval.
right, that's right. But this board needs to define it.
Correct.
And you've thrown a proposal on the table.
Yep.
And I haven't heard anybody respond to that.
That sounds good.
Forgive me.
The proposal was to have the outside of the building complete, but what I was hearing was that isn't realistic in your mind about.
It's absolutely
it's
not.
about.
Yeah.
So what would be realistic is that the site is prepared for building construction. What do you think is a realistic
Well,
way for us to
So
define?
there are a lot of things that have to happen in this sequence, and I think that what people is helpful to remember is there is no risk to Newmarket if we do nothing. The risk is only to us. So in the process, we're governed by an AOT construction permit, right? So if we start some work, if we don't do some work for a period of time, we have to reclaim all the area that we're working on. That's expensive to do. But there's never and also it has to be bonded. So there's never a circumstance where Newmarket's at risk. It's an open piece of land right now.
Right. So, but getting to the point of that, if we are going to be defining it, what would you say is a good faith? What would you say would make sense for us to say this is reasonable, that this reflects active and substantial development at that time?
I guess I'd have to sit down with the project and go through my construction sequence with my contractor to outline it as part of the construction management plan.
So I'm
So
sorry.
there's not even, well, last question, just, so there's not even kind of a minimum that will definitely be done in 2 years, because you expect it to be done in the next 4 to 6 months? I mean,
Oh, clearly, we could say things like
Clearing the.
clearing, grading,
right, that's what I was looking for.
yeah, those types of things, yes. But again, when you start, that's miles and miles away from a building on the ground.
Right, no, I agree, yes.
Go ahead, Diane. Hold on,
Just
hold
I
on. Let
wanted to
Diane say
say,
something.
just before the meeting, the chairman, can I tell
ahead.
him what you and I discussed and came up with this possible scenario?
Yeah.
Just for discussion purposes, excavation, site work,
Right.
slope stabilization, landscaping, the berm. Once those pieces are done, then the site would be pad-ready, as Mr. Graham alluded to as the industry term. At that point, would that be a reasonable place to say, yes, if all those things occur, active and substantial development has occurred?
And I would say that's probably really going a long way.
going a long way.
Really, because
Okay.
let's just use a good analogy to make is, if you say you have to have a building standing, that means a lot of other things have to be completed. The statute doesn't say I have to complete anything.
I didn't say I didn't say the building, Valerie's.
I understand that, I'm just using it as an example.
Understood. Right,
All it says is we have to start them.
right.
Well, but it doesn't say how far.
Well, hold on. Okay,
Yeah,
Jane, you haven't been heard from.
Yeah, and I apologize. I have never heard anyone say, we may do nothing. We don't know what we're going to do. I'm kind of floored by that, right?
That's all right.
And I get that's your right, but I voted on the fact that you came to me and you said, I want to build a building. I want something there because I want to do something good for Newmarket. I want a business. I want to create jobs. I want to create opportunities. What I have heard you say is, I want to dig up dirt. And maybe over an extended amount of time, hopefully before I die, you will build a building. Maybe, because that's your right. So help me understand, what are you really and truly asking this board? Because I'm scratching my head because I just don't get it. I hope I'm
Jane,
saying
think-
that the
I
right
understand
way.
your question, but we have a site plan in front of us, and they're asking us to approve that.
Yeah.
Any site plan we approve does not require the developer to build it.
I absolutely
The
get that, but
developer at
I've
any
never
point
had a
could say, "I don't
developer
wanna do
come
that."
to me, though, and say, I might not do anything, but I know what I'm gonna do. I'm gonna open the road out so I can get trucks in and out.
That's not
I
what he
just want to
said,
be
though.
I
clear.
think this goes back to, we're looking at the excavation as incidental to the building.
Right.
And that's what we talked about
Right.
almost a year ago now. It's incidental to the building, therefore, it's not requiring an excavation gravel permit. You know, because clearly, we want it to be incidental to building a building and putting a building on the tax roll. That's the goal of the approval of the site plan. So I think this is really, okay, well, how does this not become an excavation project?
Right.
De facto.
As
Right.
opposed, a gravel pit project, as opposed to, we're getting this
Yeah.
excavated
Well,
to
it
get
isn't-
a building ready.
I understand that question. And but I want to make sure that we make the distinction that Jane asked a good question, and it means that I'm not communicating my point very well. I'm not trying to put that limit on it. I'm saying I don't want to put, you're asking me to put a limit on my statutory rights. And when I say my rights, my client's rights. And we're afforded, when we pay the fees and we design to our standards, we're afforded those rights. That's as a landowner. These types of rights are set because the overregulation of those rights bump into the ability to properly develop and sequence construction of real estate. We could say, I would love, it would be if we'd have been through this process 10 months ago, we could be a long way down the road. I would love to be done in 6 months from now and be building a building. The fact of the matter is we've been marketing this site very aggressively to quite a few people, and that are sister users to users in our industrial park, which makes a lot of sense. But when you tell them, A, I don't know when I'm going to be approved, B, I've got to get a lot of material out of here, it puts a lot of time in the time where you can go to get an occupancy permit. You have to have this time in the front of the project to go stage the site. We call this staging the site. And that's what we're doing. We're going to rough down into a marketable pad condition that we can deliver. We can't tell a client right now, when can we occupy the building? They're asking us the same question you are. We don't have a date for them. We can't even tell them when we're starting yet. So those are the logistics that go into why the legislature provides us those luxuries, if you will, in this process. So they protect us. I'm not here to say I don't want to build something. I'm saying I'm not here to give up my rights that are mine by the due process, the law of due process in New Hampshire and in Newmarket. I don't think that's reasonable to do. We spent a lot of money to be here.
No, understood. I understand that. I mean, I guess the thing everybody has to understand is there's no protection. They could go out, clear every tree in that site as soon as they have approval and appeal periods have gone, and then the market could collapse and they never do another thing. And after time, their rights, they no longer have any rights to build anything. If they want to change it, they got to come back to us. That's a risk that they're taking.
Their rights are vested if we're determining that just clearing the trees is substantial.
Understood, exactly.
That, I think the
Right.
conversation is what constitutes that.
Yeah, go ahead.
Right.
So we need to decide.
Right.
If you don't mind, I would just like, I think there's been a lot of, discussion on this, and I think this, just one example will help clarify things, because it's not that, Rob would go out there and be required to complete anything within that 24-month period, besides the fact that he would be required to start construction and start active and substantial construction on the project. So that if you said, well, let's define what active and substantial is, and you were to say, well, let's call it starting on the building, well, that would mean he would be required to start on the building within 24 months, which the law clearly does not require. He may be delayed for 24 months and go, okay, the 24-month is here, let's start excavation. And that would clearly be active and substantial construction, because now they're starting within that 24-month period. The start of that construction, they're still within their time frame. They're allowed to do that. They still have their site plan approval. The determination by the planning board would then be, yes, they've started construction. They're out there clearing and grading and actively constructing the project. And
That's
they would
not
still
the
be
statute.
vested.
I mean, we can get a legal opinion on it, but I do not read that as being the statute. It is clearly under the statute that the planning board will define what constitutes active and substantial for vesting rights.
So I guess maybe,
So let's just take a crack at it.
that's what I was about to say.
Let's take a crack at it.
Can we go
So
from
you
the
had
real
said a couple
basics down to the more detail?
Sure.
Go ahead.
Yeah.
No, go ahead.
I was
Yeah.
going to say clearing and grubbing. Is there anyone that disagrees that clearing and grubbing is?
We would agree that that would be active
that
and
would be
substantial.
active? That's part of it.
I don't see it as substantial.
No, okay. But we can all agree that it's active. Okay, so the next step would be what? Grading or excavation? Excavation would be the next step. Is that active and substantial development?
What
Given
part
the
of
scope,
excavation?
right.
Beginning of excavation?
Well,
No.
taking the
I think
materials and
completing excavation
moving-
within 24 months.
yeah, taking the material out and
Within
transporting
24.
it from the site, exporting it from the
Within
site.
24 months.
Within 24 months. Is that substantial, active development and substantial active development? there
I'm
anyone
fine
that
with it. I'm
disagrees with
fine
that?
with a substantial excavation. And I think
Okay.
that that would hold up.
Okay.
If the applicant
What
doesn't
about-
agree
Substantial
with it.
excavation not being completion of excavation.
Correct.
Okay.
I have one.
We're fine with that.
Because the court would determine, if the town is having an issue with it, and this, goes to court because he's gonna lose, if he loses his vesting rights, then, there are court cases that determine substantial, and it's based upon typically the cost associated with the entire project and how much the applicant has invested into the project.
That's,
That's correct.
yep, and I would agree with that completely.
Right, clearly from the town's perspective, the way you're being protected is that the applicant is not coming out there with a hand shovel, shoveling one piece of dirt off the site and going, that's active and substantial completion. You guys want to see a real start to the project.
And I
that's
think
what we're
that
trying
that
to accomplish.
would address, I think, maybe, I don't know if it's this board's concern, but this is, I think, will address this issue of that it's not a gravel pit operation. It's not an excavate, it's
Well,
not.
that's
a
the
gravel
question
pit.
I was going to ask, though, is that if, going back to the time before I was here, when the board made a decision that it was a development project and not an excavation project, would that have been the time, would it have been appropriate then to ask about the schedule then?
We did.
We did.
We did, and quite honestly, we have, it's not in our purview to dictate what the schedule needs to be.
But it is in your purview, it was in your purview to decide whether it's excavation. So if they retained all the rights to wait however long they want to before they do any building, but remove the material right away, how do you determine whether it's excavation
Exactly.
or development? It seems to me that's the challenge in that situation.
It absolutely is, and the only decisions we can make are based on the facts that we have in front of us, which is.
And we're just stuck with each other.
Which is, right, exactly. Which is
And
this saying they're
the
gonna
fact
build a
is, I
building.
just want to make sure I clear something up for everybody. That material in the ground is worth about $1 a cubic yard.
It's more than that. I'm sorry, I own a
They own
gravel
a
pit.
gravel pit.
I own a gravel
$2.
pit. It's worth more than that.
Well, you're selling it. We're paying to get rid of it.
But
No,
it's
you're
still,
not.
Yeah, we are digging down to prepare a site.
But, I mean,
Hold on, one at a time, one at a time.
just one quick point. I think
No,
Val
you have a
articulated
taker.
it perfectly early
Exactly.
when she said, this is what you had talked about. You want it for the benefit of Newmarket, you want to do better, better, better. We're talking about a revenue stream back to the town and to make it work. That's really what the conversation is about, right? The promise that you've made and then the delivery of that promise. Is that a fair statement? And then we can kind of go to, maybe take your thoughts and put that into a motion. Is that fair?
I have it as part of 8.
And I agree with, I agree with the start of substantial excavation as,
Well.
Rosie,
and-
hold on, one at a time.
and
Rosie, ask a
also,
question.
Could you said I could ask the
Yes.
applicant later as to whether or not Mr. Porterata and the other property is part of the 100,000 square yards that are going to be removed.
it's cubic yards, first of all, and no, they're not.
They're not.
No.
No, that's
They're
not on the
part of-
site
They're not part
plan.
of the site plan.
They're not part of the
They're not
site
part of what
plan.
we're approving. Those
The
properties.
excavation is only relative to what's on this site
To
plan.
what's on there.
Right.
Yep.
Okay.
And they've actually moved the excavation
Further
line
back.
back away from Porteratus's property to provide some buffer
Buffers.
to minimize the impacts on the
So,
butters.
so with this approval and the site plan, the way everything's going and the purchase of those two properties, they will not be allowed to go further into those two properties to excavate anything else?
No.
Correct, unless they come back to
Can't go
us,
into any of them.
any of them.
Okay.
Yeah.
but they could come back and ask for the houses,
They could come under another site plan.
yeah, under another site plan, and just get rid of the houses.
Okay,
and
but
use
at
the
that
property.
point, that would, yeah,
It'll be a
okay.
whole different discussion.
A whole different
Yeah.
discussion.
And hopefully another building.
And you said before, I think, that you needed X amount of time because you weren't sure about who would be buying the product, and if you had to just truck it off for the sake of getting it off there in a timely fashion, it would cost you $700,000 to $800,000 to do that. And so you basically don't have anyone ready to...
We do not have a signed tenant for this
No,
building, no.
not for the building, but for the product coming out, for the
No, we don't.
You
That's-
don't,
right,
okay,
that's-
so, but that gets to my point.
But we don't need to have that.
But that has, right, that has nothing to do
No,
with us.
I just want
private
to
matter.
clear
Right.
something up. When asked about the, if there was need to do any improvements on the southbound side of the exit out of Forbes Road because of all the gravel trucks, he emphatically stated no. They're going to be going southbound. So do you have a site ready for this gravel already? 'Cause that's what it sounds like.
I think the question
That's it, that's beyond our purview. You can, once you get on the
No, well,
public ways,
he's
they can
making,
do
he's
what they
making a
say.
statement to the planning board as an applicant, that he needs X amount of time in order to excavate that property, because
Right.
he's not sure where it's going. But when asked about a...
Which is really none of our business, how long it takes him to
It's-
excavate his property.
Well, it's part of what the timeline that the planning board could do is substantial.
that's right,
And all
that's a-
that, so that
right.
plays into that as to what his needs are as an applicant in order to develop this. And he's told us that he needs X amount of time in order to excavate that, because he's not sure where it's going, the bottom can fall out of gravel, so forth and so on. But when asked if we need a southbound radius on the exit to Forbes Road to 108, he emphatically, within a moment, said no. Why would we're going to be going southbound in 101? So it sounds to me like he has a site ready for the gravel. And I just want to
No, I think
clarify that,
I
he's
don't-
contradicting
Okay.
himself.
No, it's not.
But I don't think that's the issue. Perhaps your issue is these improvements, if large gravel trucks are going northbound and that particular turning radius in line of sight isn't done yet. We know the line of sight's gonna be done, but is that more your issue?
No, he
But it
said...
doesn't matter to, it's not
But
on the
it's
purview
not
of the
a true
planning board of
representation
what
of
he's
what
doing
he's-
with this.
But it's not a true representation of what he said in regards to how much time he needs to excavate, Because it sounded like he has a place to go.
That's, yeah.
That's just my,
That's your
that
take on it, that's
statement,
fine, but I
Okay.
disagree with you, and,
all right.
and it's not our business. They get on a public way, they can go anywhere they want to go. North, south. I would tell you that if I did any business in Newmarket, most everything goes south, because there's nothing north of there's nothing
Okay.
going through Newmarket to
So-
sell gravel to, or give gravel away. And I understand his concern. I'm working on a project that has 300,000 yards of excavation. They can't give it away. They can't give it away. So not everything is as valuable as we think it is.
Well, you
I
should
find
call
that
us, because
hard
we
to
have a lot of
believe.
people calling, looking for gravel.
Well,
yeah.
Well, I want to just clarify a couple things, because
All right.
And we don't have enough-
there's something in the air here that I just don't understand. And I want to make sure that, because there are industry aspects here that I'm not going to take the time to go through with, because I'm sure you guys don't want to listen to it. But, first of all, there's very little economic activity in Newmarket to go sell material to.
Correct.
This is not gravel. This is sand. Secondly, a truck turning south out of this movement doesn't affect this radius.
correct.
Okay, so there are no south improvements on this radius necessary for a truck.
Correct.
No one has an issue with that.
Most of the places that you would drive to come out of this park that have anything going on where material will go to, you have to you take a truck speed, and we've done the math to figure out what truck route you're going to go. You're going to go the route that's the straightest and the fastest to move it. We could drive to Lee via Epping faster than we can drive through Newmarket on the back roads. Categorically, I can tell you, we're not going that way. We're not going through downtown Newmarket with gravel trucks. That's just
Understood.
It's just not.
Understood.
So that's the nature of my comment there. I'm not here to deceive the board about an evil gravel conspiracy.
Let me stop the discussion on that anyways. We've gone, I think, way off base on that. We need to resolve, so Val, your latest comment, or I think your latest thoughts were, we say the site is cleared and substantial excavation has
I'm
begun.
proposing substantial excavation shall constitute active and substantial development or building.
And I'm okay with
And
that.
how do you define substantial excavation?
It's going to be relative to the project.
You thought you were going to, your goal is to be pad-ready in 2 years from approval? Is that a fair assessment?
No,
No.
he's saying
No.
that
I
that's,
I
No,
think,
that's a
I think that
discussion we
I'm
don't
comfortable
wanna get
with Val's language,
Right.
and I'm comfortable with the board determining what that means if we bump into that 24-month
Right.
period.
Because planning department could, or the code enforcement officer could say, you're not, this plan is not in compliance with the conditions of approval. It's 24 months. The applicant's going to have to come back to the planning board and argue that. And
Right.
if,
If we determine he's not,
Right.
then,
exactly.
right.
And if if the applicant disagrees with the planning board, he has the right to,
Appeal it.
appeal it.
Appeal.
Right,
Superior Court.
right.
Right.
I'm fine with,
Okay,
I'm fine with
so-
it. Straw poll here. Are you okay with Val's suggested for
Yes.
construction? Rosie?
Does it include the building?
No.
No, it's just the
We do it
excavation.
as a formal vote.
Well, yes, no, let's, I just want to.
Well, it's going to be incorporated right into that.
after.
I would be okay with it if only if all the excavation was completed at the time, not
Okay.
just started.
Okay, Janice?
I want to see a building there.
We all do, but
all
that's,
do.
that's beyond
You're
our.
gonna get there.
And you said by law you have to give 24 months. Is that correct, what you said earlier?
For vesting of the
Vesting.
site
Vesting of the
plan.
development to protect it from further changes in the zoning or subdivision or site review regulations.
This is to protect the developer. He was absolutely right. It's nothing to do with
And we need to
us.
define it so that administratively we'll be able to deal
Yeah,
with it if
because,
it becomes an issue.
Some things take longer than, I
And-
understand, some things take longer, some things don't fall in place, so, yeah.
Okay,
I
so
would
Val,
go-
you're obviously okay with it.
Yeah, and-
I'm okay
yeah.
with it.
I'm okay with it.
Okay with it?
Yeah.
Well, just give me a little more idea. When you, what was the wording you used about the excavation? Is it going to be pretty well completed or somewhere in the middle?
It's
You know,
substantial.
because substantial is a very vague
75%?
term.
No,
50%?
no, I don't think we want to throw a number on it. Substantial.
No,
How do we?
Well, I don't know what you mean there.
Hold on, quiet, one at a time, please.
because substantial is going to be relative, or, the courts will rule that substantial is relative to the project scope of the site plan, not of excavating out the
Well, the
front.
whole project is much bigger than excavation, but on
Right.
that
Right.
point alone, it seems like
Getting-
that has been such an issue in the beginning of it, that it ought to be a little more clarity. Maybe you don't want a percent on it, but I would like to know what people are thinking. I mean, you know, that seems like a reasonable question to ask, whether you're talking.
Oh, absolutely. What are your
Most of the
thoughts?
material out or
As a layperson,
some of the material
I think
out?
substantial is pretty much most of the material out.
Yeah.
90%.
And there could even be, Diane, you may know, there might be an actual definition.
Can I just interject real quick? Go ahead. Again, with the example of active and substantial, and I believe the intent of the RSA, and again, this is just the intent, and has been worked through the courts, that the intent of that active and substantial construction is that it begins within 24 months. So that is a vested site plan approval up until the 24 months. They say month 23, they have active and substantial construction begins, and that 23rd month or week before.
That's not the statute.
I believe that is what the intent is.
Try to define what substantial
Yeah, I would suggest we would want our own legal opinion on what, if we're defining something.
So I guess my point was that if then a law changes and then it comes back to subject to someone saying, well, no, that site plan approval is no longer vested, then the applicant would come back before the board, and the board would say, well, what have you done to have active and substantial construction have begun? And then you look at the site, you look at the conditions, are there actively and substantial construction operations happening? If you can then define that as the board as yes.
Yeah, it's a judgment call on the part of the board, and it's not necessarily something you can define by a formula or a specific definition.
Right.
And then too, all 67439 does is we do approval, they have 6 months to get all their ducks in a row. If they don't, they can come back and the state's this, that, and the other thing. Then they have 24 months, according to the RSA, for substantial improvement.
Right.
And all that does is protect them from changes in ordinances of zoning.
Absolutely.
But
That is correct.
if they do not have any type of substantial, we could say they have substantial. Okay, we could say they take one bucket of soil out and it's substantial and they're done, they qualify, okay? But at the end of that 5-year period, from when they started the work, they only have 5 years. If they haven't done anything, they are no longer vested for that building. They can't build that building. If you read the order.
Only if the rules changed.
They are
Right.
exempt from
They're
changes for
exempt
5
for
years.
5 years
And
only.
then-
So if they don't comply.
Then they have to complete it within that 5-year time frame if they want permanent vesting.
Exactly.
That's how I look at it.
So it isn't that they can excavate this to a certain degree, and then at 5 years and 2 months, ask for a building permit. They can't, because if they haven't completed the project.
That only
They
protects them
only-
if the zoning changes, something that changes.
Only.
That doesn't mean they have to be done in 5 years. Protects them from
So
5
it only
years.
protects them from the zoning changes.
In 5 years. It doesn't mean they have to be done the
And
project.
if the project is done, then it protects them permanently.
Well, they only have to have the active and substantial development or building, is the actual language.
For the first 5 years.
Right.
Right.
And the planning board defines what that is.
Right.
What is that threshold?
Okay, I think we started that discussion.
Yeah, and
now,
just to
because-
make sure everybody understands, because we're leaving a word out, the word is "has commenced." Okay?
Right here.
That's what the statute says.
Oh,
No, but where's it?
Active substantial development has commenced,
Right.
okay?
What section are you reading from?
I'm reading from Diane's memo.
Oh, that's not
That's not
exact,
what-
that's not
yeah.
RSA.
That's not the RSA.
Just to
Sorry,
clarify,
guys.
though, it seems like the whole point here on the town side, right, is just that we're looking for the developer making a good faith effort towards building it based upon the code at the time that we approved it, right? And that's and so I think though that if we're talking about substantial excavation, if it's a bucket of sand, I think the common sense, and I think it would be upheld, is that that's not substantial excavation.
I would
right?
agree.
And I think that if 2 years have passed after these approvals and it seems like it's not a substantive amount, then
Right, but I
We would
don't
say
think a
that, but-
third is what we're thinking about either.
Why
That's a
don't we
lot more
just,
than a bucket.
I mean, an engineer can look at the
Third is-
plan and can tell you how many cubic yards of gravel will be excavated as part of this project. It's a fairly easy calculation.
Well, there's, and there,
So if you can quantify it by saying, we consider substantial excavation to be 50% of that, 60%, 75, whatever. What we need to do is just define it so that we've done our homework.
I think the courts have defined it.
Can I just ask? So, so I'm not from here, obviously. I'm from Delaware. We've had, and where I'm from, we had an issue where there was a project that nothing was done at all, and so they lost their vested interest in it. If they wanted to do something, they would have to reapply under new code. But that was basically, it was a very clear cut, like they hadn't done anything at all. And so I don't know in Newmarket or, if we have a history of there being issues around this.
We have many approvals outstanding.
Right.
Where they're vested, because they grubbed the road in.
But so I'm saying where there's, so you're saying where they're making just enough effort to be vested, but not
Right.
kind of intending to continue.
Grading.
These go back to the 80s,
Okay.
1980s.
So that's where this is coming from in terms of wanting to have more clear definitions. Okay.
Right, and unfortunately, there are horror stories. You can go to any town and find horror stories. We do happen to own a lot of real estate in this town.
Right.
But, there are a lot of things that can be substantially active and substantially started that aren't necessarily the excavation. So if you came out to the site in 2 years and you saw that we had begun to grade down the site, we had put up the buffering for the neighbors, we had reclaimed some of those areas.
Well, that's what
We had done other work out in the intersection, and we had done a lot of different things that
And
were
that's
for this
where I was going
development.
with my description.
You might look at that as active and substantial. It might have nothing to do with how much material they had left the site.
Right,
Okay. Well,
right,
that's one way to define it.
And it's active.
right,
There
right.
isn't a right answer. This is a policy decision that has to be made by this board. And the more clarity we can provide, administratively, the easier it will be.
Well,
I-
It has to be
I'm
enforced
actually-
in the future.
Fine with clearing and grubbing and excavation has begun.
Okay.
Was it
the
the original?
Okay,
It's
why
hard
don't-
to throw a quantity on.
All right, well,
I feel if the developer cannot clear a site to get ready for a building, doesn't have to start the building, but if he can at least clear a site within 24 months,
clearing and excavating.
excavating is,
Okay. All right, we heard you.
Why
Okay,
doesn't
go ahead.
somebody
Let
make a
Val
motion?
speak. Hold on. Let Val
Let's
speak.
just put a perspective into this. The project directly across the street had substantial excavation associated with it, and roads built, et cetera, and I'm not saying you have a similar market, because it's extremely different. But I don't think just grubbing the site, because we have a lot of those approvals from the 1980s where the site was grubbed and now they're vested.
Right.
But
I agree
let me
with
ask you this, and the reason I pause at that is that, first of all, there's a market out there that we know nothing about. He may not be able to find anybody for the building for 3 years, 5 years, or whatever. And if he grubs the site and does nothing else, how is the town damned? How is the town hurt? I would argue the town's not hurt at all.
Well, you're missing the word active.
I think
You have to, it's not enough to do something and then stop
it
No,
has
so,
to
but
be
you could-
ongoing.
until you're substantially complete.
Right,
Has to be
right.
ongoing.
But you could do that, and you may not have a.
The town's not harmed. There are bonds for the reclamation of all of those areas, and it's our property.
Right, no, that's what I'm saying. The
And
town's
it's
not harmed
our
at all.
issue. So it's like,
That's-
And that's my point. If the planning board in 24 months from now does not believe that he has, or if it comes back to the planning board because the code enforcement officer doesn't believe that it's substantially,
Begun.
the excavation has been
Then
substantially
you're pushing that
completed,
decision on him.
then the planning board can come, then they would come back to the planning board, either looking for an extension, which is permitted in the RSA,
Right.
right? Or a determination at that point in time
Right.
relative to the project.
So what you're saying is we
So-
don't need to define it.
That's my opinion.
Well, you-
I'm fine with that
That's how
too,
we-
to be honest with you.
We've gone over and over that, we do have to define
We
it.
do
You
have
went
to
so far as
define
to
it.
say that it should be.
I don't think it's
a building
defi- I don't-
started.
I-
It
I-
states- This is-
My
We're just spinning our wheels
proposal
now.
is
I'm
that,
sorry.
that
I thought we were
what
making
constitutes
progress
active and
here.
substantial development or building under the statute is substantial excavation. That's what our discussion has been centering
Okay, well,
around.
what is substantial excavation?
we would be comfortable with 25% of the material or any other improvement that the board seems as reasonable, as active and substantial.
Well, yeah, I mean, I'd like to see some stabilization of the area.
Well, they'd have to
They
under the
have to do
AOT
that.
They have to do
permit.
that
Just
first.
excavating isn't really an ideal
You can't,
situation.
you
But the-
can't stabilize it until you
Right.
finish it.
gotta
But
finish-
also, but during construction, that's
They have-
But you could do it
handled
in
by the
phases.
AOT. That's handled by the
The
AOT
AOT
permit.
would deal with that.
Right.
So,
If you're actively digging through a face, you don't restabilize it.
Right.
How long is the alteration of
I
terrain
realize that, you
permit
do it in sections. That's
viable?
what I'm suggesting.
Is there a
Phasing.
limit on the
5
alteration
years.
of terrain permit?
5 years.
5 years.
5 years.
5 years.
Which is the same thing we're talking about.
I mean,
The only thing that I'm struggling with is that anytime I do anything, I always look on what's my return on my investment? When am I going to get my money back? Are you telling me that you've got $500,000 out there invested in purchasing a property and other things that you've done? And you're saying to me, I got to wait all these months and years to get things done because I want to protect my rights. Aren't you protecting your investment as well? I mean, I don't think you are. And I'm scratching my head sitting here saying, again, I've never had a developer come in and say, yeah, but I really want a really long time because I don't really care about return on my investment, and I want this to go out even longer. And I understand that that's a
That's
separate.
not what he's saying.
No, but
That's not
that's
our
the
business.
perception
Understood.
that I'm getting, right?
Understood.
It may not be the reality, but if I'm a voting member, that's the perception I'm hearing. I think Val's point is the one that we should go with. I think it needs to be more than just, the putting out the shrubs and all of that. I think there has to be something that has to be substantial that lays to the foundation of what this building is going to go on. I
That's
think
completely
that's what we're looking for. I
unacceptable.
think
unacceptable?
Val's statement is the one that we should go with.
Which is what.
The excavation, that's what I'm saying. If you got the excavation going, I think Val's offer is the one to look at.
That I'm fine with. Substantial excavation, I'm fine with the board determining that when we get there. This board's not going to be the same board.
Right,
We've already seen 2 changes of this board.
right. Well, we gotta talk about it. We're not just gonna have a motion for the sake of having a motion, Diane. I mean, we gotta come to some.
Why don't we
talked
see-
about it.
well, I think-
we've heard.
Why don't we
we've heard
see if-
clearing and grubbing, we've heard excavation, somebody threw out 25%. Is that reasonable?
So why don't I, so I'll move that, we define substantial and active and substantial development or building, as, a minimum of 25% of excavation, and we can just see what the vote is if somebody's willing to second
Fine, is there a
that.
I think
second?
there was more than that, though.
It was
Well, that's
clearing
his
and
motion, though.
grubbing.
That's his
He's trying to
motion.
get the ball
He
moving.
can make a motion, so he made that
If
motion.
it fails, we'll add something to it. I mean, we
Is there a
can,
second? I'll second it. Discussion? Vote. All in favor of the motion, say aye.
Aye.
Aye. All opposed?
nay.
Nay.
Okay, is there another motion?
I'd like to make a motion that we grant conditional approval on, what was it, substantial and
Substantial and active development
active
occurs
development.
when?
occurs when all the material has been removed.
100%.
100%, and the radius for the road. And they have to do the grading for, under the alteration of terrain permit, because once it's excavated, they're obligated to do that. So it would be the radius, the completion of the mining of materials, and what else did they have to do?
When you said grading, do you mean stabilization of the
The
slopes?
stabilization, what's required under the alterations of terrain, or what DOT.
And you're saying the off-site improvements?
The off-site improvements, as indicated, additional under number 6, I think, from
The
Rick
plan.
Malasky.
Right,
And
okay.
that was, they also included the top grade,
Yeah, top course, okay.
The
top
the
course of
pavement, okay.
Um,
And not the
that-
building?
Is there a
Okay.
second?
And not the building, because he can't, I understand about building, he has no control about when someone's gonna sign a contract with him.
And
Is there a second?
I'll second.
There's a second. Any discussion? I personally think that's way too, that's way beyond what we should be suggesting. Especially you're asking for completion of the site.
I'm
Which I think
asking
is
for
beyond.
completion of getting ready to build the building that he said he wants to build.
Right.
So it's
And
got
the
2
off-site
years.
improvements.
And the off-site improvements.
I think that's way beyond what the statute intends. But, any other comments on it?
yeah, I would just worry about, I'm saying this, but, what impact that could also have on other developers in terms of when they're looking at whether the requirements are that onerous of whether we want certain things to happen in Newmarket and whether they want to come here or not. So that would be my concern, is whether that's overly ambitious. And we want to, obviously, we want the developer to, I think Jane is speaking to this, feel ambitious, but I think there's a difference, right, between that and legislating that it has to happen or else this happens, in
But
terms
you
of our
also have to
definition.
realize it's at a site on 108 where you don't want trucks coming in and out for the next 5 years, taking
Right.
that excavation materials.
Trucks go in and out of
on
there
top.
every day with the buildings that are there now.
Right. So that,
Yeah, I mean, I
that-
drove there
that was
today.
my convoluted motion.
So, there's a second discussed. Take a vote, all in favor, say aye.
Aye.
All opposed? Nay. All right,
Let's
so-
try
Can I just say
something else.
one thing?
Yes.
I think we have to have a little bit of trust. And you and I know we got off on a rocky start, because I have a different view than what you had. But I
You
have
did.
been worked down at the TRC, and I have seen he and the engineers and Lloyd and his crew, whatever you want to call it, because at times there's 10, 15 people there, really work hard to meet the concerns of the Newmarket Planning Board and the town Newmarket engineers, which I really appreciate.
Thank you. You're
'Cause
welcome.
We hit butt heads sometimes, and not lightly, which is good.
I
And-
still like you, Janice.
Oh, good. And I do understand that he's got to move the material, and he has that right to move it to wherever he wants to move it, because that's what happens when you do construction sites, when you get it ready. And I do understand that it may not be ready in 2 years to put that site on. I'm looking at, like what
That's right.
Ezra said, about looking for other developers who may want to come here. If you say, you know, because some of these developers take a long time to get all their additional permits done and the contract signed with the person who's coming in. There's a lot of other type of demands going on. And I do feel that they have turned around and have invested a lot of money also in their plans and their engineerings to get this going. And I know there has been other developments in town with that investment right done, and those are housing developments. This is an industrial site. It's to his benefit to get that building up.
Right.
Number one, I think that's gonna be their goal. And you're gonna have to deal with me, because even if I'm not on this board, I know where you're at, okay? But I do think we have to.
We'll sell you gravel anytime.
Okay, I know people give you, who will pick up that stuff left, that's just like that, because they've called us for sand and we can't sell ours right now, ours is on hold. So, tell them to call and tell them.
All
So
right.
what do you think? You started
So
off by
I
saying we
think-
need to have some trust. What do you think
I think we have to have some
is
trust back and
reasonable?
forth here. I don't know what's reasonable, but I think we have to get to a ground that's reasonable, because
We do, but, and I look at it probably overly simplistically. The town is not at risk for anything here.
Yeah, but
We're not
we-
at risk for anything.
But if they're gonna start the excavation, they should at least get it to a point where it's an attractive site so that it can be marketed.
Right.
I mean, one of the
I'll
problems.
go along with that, okay?
Okay, so what is attractive?
So what is attractive? I would think that having a site, okay, with a good portion of the excavation been completed, and I go with 75% as a rule of thumb, that's what I would throw on the table. That the site be reasonably graded so that it can be marketed, and, let's see, clearing, grubbing, of course. And I don't think that it's reasonable to expect the off-site improvements to be done at this stage. So, I guess bringing the site to a point where it can be marketed as an industrial site would go a long way in terms of making it available to the public and to prospective developers who might want to locate there.
But that's not part of our purview.
So,
Well,
Tell somebody
but
has to make his site attractive to potential
Yeah,
buyers.
but you want it to sit there for 24 months with a raw edge of a
It's his property, I
gravel
couldn't
pit?
care less.
well, I'm
but
concerned
that's our
about that with the
industrial
aesthetics
park.
of, I mean,
That's
we're talking
our
about our vision
industrial
for
park, Eric.
Newmarket, and people are driving by
But you
108,
think
we
he
want
wants it to be like
Newmarket to be a.
that? What if the market, I mean, this whole discussion is about
Yeah, but I'm just saying, we should,
timing. And we may be asking them for stuff that is unrealistic.
is
So I
that
have a new-
unrealistic?
Just make sure everybody understands something. If you haven't worked on a face in 3 weeks, it has to be stabilized. That's how active it has to
That's why
go.
I'm saying you can't overlook the fact that it has to be
So what you want to do,
stabilized.
but what you don't want to do is rework. That's what's very expensive in a
Right.
site. And that's what we're really trying to talk about here is, and I would say as the applicant, what would help us, what the board could do to help us invest in Newmarket, and I think Ezra's comments are very important, and I think that that's the type of thing that needs to resonate, especially if this town wants to build a school someday. You got to have investment in this community and generate the kind of commercial tax revenue it's going to take to pass those kinds of revenue bonds. And I can tell you, I know the development community in this state is a very small group of people, and they know where they're welcomed and where they're not welcomed, and where they want to go invest money over time. We happen to already own the industrial park. It's different for us. Our point is, what would help us is that we think it's reasonable to require active and substantial construction and development. We think it's reasonable up to 25% of the excavation amount, and/or other items that the board at the time may determine are substantial. I think that's reasonable. I trust the board enough, I trust reasonable people to come out to a site and say, yes, you guys have been working, and you're still working.
So, if I might, so we've gone from trying to determine that all the excavation product out and have the exterior of a building, the pad and exterior of a building started, because you really can't put the...
Not the exterior of the
Has
building.
not been.
Well, it was
That
a
was
Val's.
suggestion. It was a suggestion.
Yes, which has probably been withdrawn.
And then we've gone
Correct.
to 25% of being excavated, to 100%, to the planner's suggestion of 75%. You're recommending a 25% excavation in all off-site improvements.
No, I'm not recommending off-site improvements. Our off-site improvements are timed with the construction sequence of our other trades.
Right.
So and also, insofar as the tax impact to build a new school, I think the...
Hold on, that's got nothing to do with this.
Oh, no, but, well, he
brought it up.
mentioned it, he mentioned it,
I
and
know, but
I'll
stop,
tell you
stop.
right now,
That's got nothing to do with this.
we have to build 5 Newmarket industrial parks to get $1 off our
Understood,
taxes, if I'm
understood. That's got
correct.
nothing to do with
So that
this.
has nothing to do with us
The
being
new school
able to
is
build
not
a new
part of our
school.
discussion.
Can I make a
Well,
motion?
tell him not to talk about
Understood.
it.
So I made a motion for 25%, which failed, and so I would make a new motion for 50% excavation plus some clearing and grubbing as
All clearing and grubbing.
well, can you not
Clearing and grubbing is done before you can excavate material.
for the whole? Okay.
Right.
They're not gonna clear and
So before
grub
any
an
of
area
it.
they're not excavating, because when you clear and grub, you excavate and then you reclaim.
Okay.
Go to the next site. Clear, grub, excavate, reclaim.
And the
that's all
reclaim
under
is the landscaping
AOT,
part
Well,
permit.
involved in that.
then what is
So
wrong
what
with
would be
that as
the-
a suggestion?
Well, so I'll remove clearing and grubbing since that's incorporated already
second for
into
that?
it. So sorry, so just 50% excavation then is what my motion is then, since the other part is already included in that.
Is there a second? I'll second it again, for discussion purposes. Jane, what do you think? I mean, what do we,
I still support Val's
Yeah.
original
All right.
position, which is
Which is just
removed from the
substantial.
All right,
table.
I
So
move
I
the
can.
motion.
then
You
that's-
vote.
yes?
Oh, well, I'll rescind my, I mean,
Okay.
I'm happy with, I mean, do you want to make that proposal that you
I-
originally had? We haven't had that one yet.
Has that motion been off the table?
No, it's, that motion's still on the table,
Oh,
so.
I can't rescind.
Okay, good.
All in favor of the motion, which is 50%, say aye. Aye. All opposed?
Nay.
Nay.
Okay, we're done with that.
Okay.
We can talk about this all night. Do we
I
want
know, I
to
know.
get some advice?
2
Go
hours.
ahead.
Do you have to open it up this for public comments before before any motion is entertained in order
Yes.
to
I thought I opened it up
Yes.
for public
Yeah,
comment.
no comment.
On this?
I don't think we got that.
No,
Oh, no.
yes, we haven't got that.
Non-agenda items, not on
You
this.
didn't open up for public
So
comments on
maybe
this.
we need to hear from the public and then go back and.
I thought I did.
No.
Anybody in the public want to comment on this? You guys still awake out there?
No.
Kidding? How could anyone sleep? Right, there's no public.
Are you here for the other hearing?
Okay. You can close
Okay,
that.
so, we're going to close.
Wait, we might have another alternate for the planning board.
Would you like to sign?
Your government at work, baby, your government at work.
You close
All right.
public hearings?
So I closed the public comment period of it. Go ahead, Val.
I'd like to make a motion to approve the NIP Lot 6 LLC Shearwater Investment Corporation application for a major site plan review at 2 Forbes Road, which is NIP Lot 6 LLC, tax map R3, Lot 9-6, and 181 Exeter Road, which is owned by Shearwater Investment Corporation, tax map R3, Lot 8, which are both in the B2 zone, for the construction of 24,000 square foot expansion of the existing industrial building located at 2 Forbes Road with the associated parking, drainage, and landscaping improvements. Pending the site plan approval, the lots will also be merged to make one lot. I make it with the following conditions. In reference to town planner Diane Hardy's memo to the Newmarket Planning Board dated April 10th, 2015. Items 1 through 9, with the amendment to number 1 to read, "The applicant shall enter into developer's agreement with the town of Newmarket, which includes findings of fact, official site plan approval conditions, the town's expectations prior to and during excavation and construction, requirements prior to the issuance of building permits, certificates of occupancy, scheduling, and timing of site improvements and construction. Number 2 as is, number 3 as is, number 4 as is, number 5 as is. Number 6, the applicant shall finalize the intersection improvement, and then the addition of, including changes proposed in Philip McDonald's memo dated 4/30/15. That is the only change to item 6. 7 as is. Number 8 shall read, the site review approval shall be deemed to have lapsed 24 months after the date of approval, unless active and substantial development or building has commenced within said period, per RSA 674-39. For purposes of vesting, the site plan approval shall be deemed to have permanent vesting upon substantial completion of building and site improvements as shown on this plan. Substantial excavation shall constitute active and substantial development or building. And 9 as is.
Is there a second?
Second.
Any discussion?
Sorry, I missed it in the whole thing. You changed the 12 to 24 months?
Correct.
Okay.
And we're not determining how much
So
gravel has
it's
to
up
come
to
out.
the,
Right.
up to the building.
24 months from now,
Somebody
is
can
it
decide.
substantial or is it not?
Because it may be moot, because there may not be any changes to the zoning.
Right.
So why agonize over it now?
Why did you say that an hour and a half ago? All those in favor, say aye.
Was there any discussion?
Any, I guess, no discussion, right?
Sorry.
That's fine. All
Well,
those-
just that, if they come back in 24 months and we say there hasn't been substantial, and they say, yes, there has, what is to determine what is substantial in
They can
court?
appeal if the planning board has determined at that time that the substantial
met.
excavation has not occurred, then the applicant has the right to appeal that planning board decision.
But under 674-39, it states that if the planning board does not determine in their approval what is substantial and so
It
forth.
does not, I don't agree with that.
It's a state RSA, whether you agree with it
No,
or
I
not,
agree
you
with
have
the
to comply with
RSA.
it.
It doesn't say we have to say 25%, 50%.
It says that we can specify what we consider.
Can.
We can't.
That we
don't have
can.
to.
And I am. I'm specifying
But you're
substantial
not,
excavation.
but you're not giving the amount, so it's up in the air as to how much is.
Well, and I think what Val is suggesting is at the time that happens, if it does happen, then whoever the board is at that time will need to make a judgment based on the work that's been
But
done.
then we have no standing in court because we didn't state what we felt it was, and absolutely. Okay.
Any other discussion? All those in favor, say aye.
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 All those opposed, say nay.
Nay.
Motion passes. Did you vote, Dale? I didn't hear.
I'm on the,
Or are you
I'm going to
abstaining?
say nay. I'm going to say.
Okay.
So we have 2 nays.
Yes. 5-2.
Thank you all very much.
Thank you.
We'll work to get our stuff done. I'll reach out to you, Don, with the, Diane with the, sorry, Diane with the
There,
It's a
DOT stuff and all that.
and Diane, there's a 30-day appeal period? Is that-
30-day appeal period. Yep. Thank you very much, gentlemen.
Thank you very much. All righty, next. Apologize to everybody out there for having to sit through that.
Yeah, thanks for being patient. We're here next week, too.
Try the veal.
Next on the agenda is Hayden Family Revocable Trust. Mark L. and Karen S. Hayden, trustee, Chimberg Builders, Inc. Compliance hearing subject to RSA 676-4I regarding a subdivision and special use permit at 74 Ball Hill Road. This involves a review and approval of management plan for open space related to the aforementioned development. All righty, so everybody should have in their packet a proposed management plan. And everybody should also have a letter from Drew Kefeber representing the Conservation Commission,
And my memo.
and Diane Hardy's memo, and a memo from David Viali from Southeast Land Trust.
Yep.
So this is a public hearing. Does anybody in the public have any comments on this? Nothing at this point?
They don't know what it is.
Oh, you don't know, okay. All righty.
Okay.
Do you want to go through that, Diane?
I would prefer to have the applicant,
Okay. Where's the applicant?
Matt.
Oh, there's Matt. I didn't see Matt there.
I mean, I can go over my memo, but I think he needs to explain it. Okay, sure.
For the record, Matt Asia with Chinburg Builders. We're here tonight to present a land stewardship plan. In November, we received a subdivision approval from this board, and one of the conditions of that approval was to come back to the board to present the land stewardship plan for the 21 acres of conservation land that is being created by this subdivision. At the time of the subdivision approval, we had presented that we were working with the Southeast Land Trust of New Hampshire to be the stewards and managers of the conservation land. Over the course of the last several months, we have been working with David Fiale, who's here with me tonight from the Land Trust, to craft a stewardship plan for the land that both satisfies the town's zoning ordinance as well as provides open space for the enjoyment of the town of Newmarket and Greater Rockingham County area. Land Trust manages many different parcels across southeast New Hampshire. They are experts in land stewardship. That's why we asked them to participate. I think at the time the town was in favor of introducing the professional land managers to the project. So it's simply the stewardship plan is this land trust's method of managing the land and what their intentions are to preserve it as open space so that it complies with the zoning ordinance. I can have Dave speak to the plan if that would be helpful, Dan, or
Well, why don't we stop there for a minute? Why don't I think it'd be beneficial for everybody in the audience if I read through, basically what the summary of the proposed restrictions are, because that's probably what everybody's interested in.
Sure.
Can we maybe back up? I don't know if the abutters have seen the approved plan, because we didn't have any participation from the abutters at the approval hearing. So could we back up a minute, Matt, and maybe you could
Sure, this-
present your plan and show what it is?
Try to read this. Well, since Stan, I'll do this and then I'll flip it around.
Sure.
Okay.
So in November, the subdivision plan that was approved created 10 house lots, a road, and then 21 acres of open space, with the intentions of that open space to remain wooded and open for public recreation. I'll turn the page here, a little more detail. See a close-up of the 10-lot subdivision. One of the stipulations of the planning board approval was to provide a parking area here for the general public to walk into the open space. There's an existing trail network you can kind of see in this aerial within this woodland. This is a hill, Bald Hill, and the top of the hill is the highest point in Newmarket. So turn around for the board and for folks at home. Again, a 10-lot subdivision with 21 acres of open space that are created by the subdivision.
Okay, thank you. So, go ahead.
I was going to give some background as well
Oh, okay, go
for
ahead.
the abutters. This is a residential open space development, which is allowed in the R1 district, which is a rural, low-density rural residential district. It is allowed by what's called a special use permit. And we had some hearings last summer. I don't know if you attended those hearings or not, but at the August 12th meeting, the planning board approved the special use permit to allow this type of development, the concept, if you will. And one of the conditions was that there be a land stewardship plan, which is a requirement under the town's regulations. And just to give you an idea of the things that a land stewardship plan is supposed to protect, it's supposed to assure that there are measures in place to correct potentially destructive measures such as erosion, a maintenance and operation plan to maintain the stability of the open space for natural resource and cultural resource purposes, for management of the woodlands, and for buffers, landscaping, and the preservation of wildlife values. So we asked the applicant, as part of that approval, to come forward with a land stewardship plan. And at that time, it was up in the air as to who would own the open space, and there's 20 acres of open, is that right, Matt? 21 acres of open space that will be protected. At that time, it was up in the air as to who was going to own it, if it was going to be owned by the town, Conservation Commission, or whether it would be owned by an outside conservation entity. And over the months, through negotiations and so forth, the applicant has come forward with a proposal to have the land, the open space land, be owned by the Southeast Land Trust. And they have put together the land management plan that's required. And I think at this point, I'd turn it over to the gentleman from the Southeast Land Trust who's here to kind of walk you through what's in the management plan so you understand that.
Oh, I was going to do that with a summary of the proposed restrictions.
Oh, okay. You want to do that? You
Yeah.
go right ahead.
Yeah. So here's, I think, the things that everybody's concerned or would be interested in. So there's a bunch of restrictions that are going to be placed on this property. And here's the first one. The property shall not be posted against pedestrian public access so long as such access is for passive recreation during reasonable hours. So the public has access to the property during reasonable hours, okay? Second one is the land manager reserves the right to post the property against hunting and camping. And I'll address that a little bit later. The Conservation Commission comments on that. The third item was the land manager reserves the right to post the property against public access during harvesting and other forest or land management activities. So if they harvest trees in there, they have the right to shut it down during harvesting for protection of the public, I guess. The property shall not be subdivided. However, the lease of any portion of the property for allowed uses shall be permitted. In addition, boundary line adjustments consistent with the conservation purposes of the property are allowed. So it can't be re-subdivided. There could be changes of the lot lines if somebody behind it or whatever wanted to add more land to it, they could add it if they wanted to, or things like that, but it's not going to be re-subdivided into another development. Construction, placement, or introduction of structures or improvements onto the property shall be prohibited except for structures and improvements which are used in the accomplishment of agriculture, forestry, conservation, habitat management, outdoor education, or non-commercial outdoor recreational uses of the property. Number 6, mining, quarrying, excavation, or removal of rocks, minerals, gravel, sand, topsoil, or other similar materials on the property shall be prohibited except in connection with any improvements made pursuant to the provisions of Section 5 above. So it's not going to be a commercial mining operation or gravel operation or whatever. Number 7, removal, filling, or other disturbances of soil surface or any changes in topography, surface or subsurface water systems, wetlands, stone walls, or natural habitat shall not be allowed unless such activities are in connection with the agricultural, forestry, conservation, habitat management, outdoor education, or non-commercial outdoor recreational uses of the property, which is kind of saying the same thing. They're not going to go there and change topography unless it's related to something that they're allowed to do. There should be no dumping, injection, burning, or burial on the property of any man-made materials then known to be environmentally hazardous, or lawn clippings and other yard waste. Pretty self-explanatory. In all open space land is designated in restricted open space in accordance with RSA 674, paragraph 21A, and shall be enforceable by the town of Newmarket. So those are the things most of the things that can occur on the property. Now, the Conservation Commission, I know Drew is here, commented on this plan, and they had a couple of comments. So Drew, would you come up, please, and just elaborate on the two issues that you had, or the Conservation Commission had?
Sure. Good evening. For the record, my name's Drew Kefeber. I live at 50 Elm Street, and I'm the former chair of the Conservation Commission. I'm the current vice chair. I'm happy to step aside slightly. So the Conservation Commission reviewed this land stewardship plan at our meeting last Thursday evening. Had an extensive discussion related to it. The two comments that we had, from a large picture point of view, let me back up and say that the Conservation Commission was approached regarding ownership of this property. The Conservation Commission was not excited about the town taking ownership of this property because ownership of the property requires management of the property and associated expenses to the town, either in man-hours or dollars or both. And given that the property was not providing a significant public benefit to the town that would only be achieved by the town owning it, it didn't make sense for the Conservation Commission for the town to own this property. In other words, the public benefit that's to be derived from this property being open space would be achieved whether the town owned the property or not. And therefore, given that there wasn't a significant public benefit to the town, for the town to own it, it didn't make sense for the town to own it. So, having said that, the Conservation Commission is very interested in seeing the property conserved and being properly stewarded. One way for that to occur is for a land conservation organization to be the long-term owner of the property, since one of their areas of expertise is in land stewardship. So when the Southeast Land Trust came forward as a willing partner, we were excited by that. So having said all of that, as it relates to the proposed land stewardship plan, there was some concern by some members of the Conservation Commission related to restriction number 2, which could potentially restrict hunting on the property. There were members of the Conservation Commission who were very interested in seeing hunting be permitted on the property. During our discussion, it was also acknowledged that given the location of the homes and a 300-foot radius, which I believe is the current state regulation for a safety zone, there would actually be a fairly limited portion of the property that would be outside of that safety zone and therefore truly reasonably acceptable for hunting. So that was a concern that was expressed, and also a known restriction associated with that. The other comment from the Conservation Commission was related to forestry. Within the stewardship plan, forestry is mentioned a number of different times. And just from a point of clarification, the Conservation Commission was interested in trying to learn, was forestry something that was planned in the relative short-term or foreseeable future, or was that language included for a longer-term management plan associated with the property? And then I would say that this letter was written to the planning board members, and at the same time, this letter was also provided to Matt Asia and Dave Viali of the Southeast Land Trust. And Mr. Viali has responded to the concerns brought up by the Conservation Commission, and I would have him address those if that's appropriate.
Yes, thank you.
And if anyone has any questions, I'm happy to answer them.
Did you hear from any of the your colleagues on the Conservation Commission relative to the Southeast Land Trust responses?
No, nodded.
Have you, because this was sent to all the conservation members, the response from...
Yes, it was, and I have not heard anything from any of the Conservation Commission members. Any other questions?
I've got some questions, but I'm not sure if they go to you or to the other gentleman that's
Sure.
here.
Why don't we bring the other gentleman up? David Viali, is that?
Viali?
Viali? Okay, great, thank you. And you're with Southeast Land Trust?
Correct.
So could you just, I guess, real quickly walk us through, do you steward any other land in Newmarket?
Yeah, Piscasset Greenway is a perfect
Okay.
example.
Okay.
It's a property that we own and manage.
Yeah, okay. And then, do you want to go through your responses to Drew's? Do you have those in front of you? If not, we have them here. You have them?
I do,
Okay.
yeah.
Okay, great.
Yep. So in regards to the first comment about the reserved right for us to be able to post against hunting or camping on the property, it's something that we discussed internally at the Land Trust. You know, it's sort of any property that we take on, whether we own it or whether it's a conservation easement, it just depends on the site, the characteristics of the site, what uses are appropriate. So as Drew mentioned, we looked at proximity to the houses, and I did a GIS analysis that basically put a buffer, 300-foot buffer on houses. And then I also thought it would be appropriate to include a similar buffer on the existing trail network on the property. And when you look at the property and what's left, there really are very few pockets of the property that someone could theoretically hunt from. So from that perspective, we think, it's not necessarily a property that screams out a guaranteed right to hunt on the property. And so the way that we're approaching it is to sort of keep it as it is now, leave it up to the landowner, whether they decide to post or not to post against hunting.
The landowner is the...
Would be us.
Okay.
Yeah, and I would expect that we would post against hunting on this property. If something changes in the future where it becomes more appropriate for that allowed use, we have that flexibility to allow that use in the future. So that's how we're proposing
Okay.
to approach that.
Okay. And the second question they had, the forestry?
Yeah, forestry, again, we actively manage a lot of the properties, including Piscasset Greenway, for forestry. And number one, our goal is wildlife habitat. Our forestry activities are not financially driven by any means. And actually, we frequently take a loss on the costs of the forestry activities. For this property, it's not a property that we see as a property we're going to actively manage for forestry. 21-acre woodlot, steep slopes, close residential proximity. The cost of getting equipment out there and actually doing a timber management, A, could be prohibitive, B, doesn't really suit the size of the property or the goals of the open space, which are really for passive recreation for the community. So maybe we would do some forestry, which in the future, we don't envision doing any right now. If we were to do forestry in the future, we think it would be related to habitat improvement, potentially to close some of the trails that are on the steep slopes, drop a tree so that the trail is essentially closed. There has been discussion, the fact that the property has the summit of the highest point in town, would it be interesting to open up a view from somewhere on top of the hill? We haven't said yes or no to that. That's something that I think we would need to look at more closely to see what's appropriate out there. But that might be another example of when we might do a small scale cutting of trees.
Okay, great. Thank you. Does anybody have any questions? Go ahead, Gina.
Is it, okay, you mentioned during reasonable hours.
Mm-hmm.
When you manage other lands, do you have like a time for what reasonable hours are?
Dawn to dusk.
Okay, because I could see someone thinking reasonable hours could be earlier than what you think, and they're having their ATVs running through the woods there.
Yeah, this property, we're not allowing motorized vehicle use
Okay.
on the property, and we may need to actually put a gate on the access there to manage that use, but by reasonable hours, we essentially mean dawn to dusk.
Okay. And number 4, it says the property should not be subdivided. However, the lease of any portion of the property for allowed uses shall be permitted. Could you give me an example of what an allowed use would be?
Yeah, so under the proposed restrictions, we would be allowed to conduct forestry if we thought that would be appropriate on the property. We're not restricting agriculture, so if we put a community garden at the summit of the hill, for example, that would be allowed. Passive public recreation is allowed. Basically, what we're doing is extinguishing the development rights. That's the major accomplishment here by the open space.
Okay. And there was talk, in one of the TRC meetings that we went to, was about having accessible for the handicapped,
Mm-hmm.
for those who happen to be in wheelchairs that came up. Whatever happened to that concept? Because
We talked about that briefly, Dave. You want to fill her in on how the land trust is going to handle that type of request?
Yeah, my understanding of the state law is that if there's someone who needs motorized assistance for that type of access, they're allowed to it. We can't restrict that. But, my understanding of the law is it's also you have to use what's appropriate to the trail system that's there. So if right now they're essentially existing wood roads, so you could go on there with a decent, vehicle that wouldn't be causing erosion or, tearing up the soil. But for, another example, if it were the Piscasset Greenway and the tread or the width of the trail is only, I don't know, 10 feet wide, you couldn't take a pickup truck through there. You'd have to find, an appropriate vehicle to use that. So if someone needs assistance by, say, motorized vehicle, they can go out on the property with an appropriate vehicle that's not going to do harm to the property. That's my understanding.
That's not what I had.
Anybody have anything else?
I was just wondering, in any of the places, I know that there's kind of this small parking area and then an unpaved parking turnaround area. I wonder if there's going to be any bike racks, if that's appropriate for the space.
Bike racks?
Mm-hmm.
It's not our sort of
that more
role
for
in
Chinburg
the
then?
plan, so that would be up to the developer.
Yeah, that would have been part of the plans that we approved, and I don't think we requested any, so
Okay.
there are no plans for bike racks.
But it's a very good point.
Question, yeah. Why, these gentlemen, it still is, anybody in the audience have any questions, anything you've heard now? Sure, absolutely.
Does Dawn eliminate camping?
Yes, yes.
Yeah, we're going to post against camping. We're not going to.
You're going to post it as no camping?
Correct. Yep.
Because I.
Question also about some vehicle that's on the
Oh, excuse me, sir, could you come up for the record? Can you come up and talk to the microphone, please, just?
My name's Angela Petrini, and we purchased 64 Bald Hill Road in December, so we had no knowledge of this, which is really kind of disappointing because we moved there for the quietness and the trees, and it's great. And
You're at 64 Bald Hill Road in Newmarket?
Newmarket.
Newmarket, okay.
Yeah. But now we have no choice, and we have to deal with this. But there are two pieces of equipment, a car and some sort of camper, that are now owned by the trust because it is on their property. So we were hoping that they could be removed.
Where are those?
I think that was agreed to as part of our TRC. We
Yeah.
talked
I like
about
that,
that.
because we didn't, there's.
What's that?
Parcels still here.
And the developer said they would be removed.
The developer's going to.
5 feet past our property.
Yeah, Diane, for the record, Diane just said that that was discussed at a TRC meeting,
Yes, it was.
Okay.
and the developer, I believe, is going to be responsible for removing those.
Okay. Thank you.
Is that it?
Yes.
Okay.
Thank you.
Thank you.
Anybody else have any questions, concerns, comments?
I just had a question, is there any, I think for the Southeast Land Trust, but is there any, would the community of Newmarket have any input into whether or not you did decide to open it up this summit, or how does that work? Or is that just something, a decision that Land Trust will make internally, or how would you proceed with that decision?
Yeah, I mean, under the proposed stewardship plan, it allows for forestry, so that would be something that our land manager, Phil Ozier, who is the former Rockingham County Forester and UNH Cooperative Extension agent for a long time, a lot of you know him. He's our land manager, so he would make, that determination along with our board of directors, whether it's appropriate and when that might happen. That's how, under the current proposal, that would work.
It's not on the radar screen at this point in time. You're just giving yourself the flexibility to do it if it's deemed appropriate.
I'd say it's on the radar, but we haven't, gone any further than saying, hey, would it make sense to maybe open up a view from the top?
Okay.
Is it appropriate for this committee to, I'm just asking, is it appropriate for us to weigh in that would be desirable? Do we have any way to make it?
Definitely.
If we think it is
I
desirable?
think we talked about that also at the site walk, because there could be some nice views of the surrounding countryside.
Yeah.
That would be a
And
significant
that would be
addition
a
to
real
the-
significant addition to the resource.
So I'm confused. Dale's saying, is it appropriate for us to
Yes,
have some
and-
input as to when that gets done, or if it gets done?
Well, if,
Or
we
is it
could have a
part-
recommendation, and we did ask them to look at that as one of the areas of concern as part of the land stewardship plan.
So
So,
basically, if we don't disagree with that on their land stewardship plan, that means we're in favor of it. So they can go ahead and clear
then
that
it sounds
site.
sounds like we're in favor of it. It sounds like
It
your
sounds like we
discussion's
are.
been.
I would say so, yeah.
I'm misunderstanding, Dale. Are you proposing that it should be part of the land management
really
plan?
asking because I'm new, is there any way that we, because almost if I heard you right, I mean, it's sort of, it's almost
want
like
to.
it could be in here and that would provide some impetus to that happening. And if there's an opportunity for us as a board to do anything that will encourage the opening up of that view, and we can do that now, then I'd like to see if we can do it. If it's inappropriate in some way, I'm not pushing on that, but I think if this is the time to give that any momentum, I'd like to see it happen.
So that could be an amendment to this management plan.
It does say in the motion for approving the special use permit that enhancement of scenic views is one of the items that should be addressed in the management, the land stewardship plan. And that was part of the conditional approval.
Mr. Kefeber.
Yeah, so I'm speaking as an individual in this particular case, and I want to make that very clear, okay?
Sure.
So I would say two things. One, during much of the year, because the top of the hill is covered primarily in deciduous trees, we actually have a majority or a substantial portion of the year when you can have a decent view from the top of the hill already. Okay, it's partially obstructed because there are still tree trunks and branches, et cetera, so it's not an unobstructed view. But there is a view that already currently exists. Another thing is, me personally, I would be very hesitant to request that it be opened up for review without having more knowledge on the soils that are there, how much area would need to be cleared, et cetera, because it is the top of the hill. And if we cut down what's there in order to open up a view, in order to maintain that view, we need to keep it cut down.
Yeah.
And if that disturbs the soils in a way, there's the potential for negative impact and erosion by wiping out what's growing on the top of the hill.
Right.
And I would be hesitant to do that, and when I'm unsure of the extent of the area that would be required to be opened up in order to provide a view as well. So, comments individually.
Are there any existing homes or homes that will be built that will be close to that area, that if it's cleared, that it will inadvertently affect their view or their peace and quiet? I mean, where is that knoll located?
Quite a ways up.
Is it? Okay, so it's not too close to.
Go ahead, Val.
Under one, on the proposed restrictions, the property shall not be posted against pedestrian public access, so long as such as passive recreation during response. So are you reserving the right to post against bikes or dogs or?
Bicycles, yeah.
Yeah, I would say so. I mean, if it becomes to the point where it's becoming detrimental to the property, I mean, when you see the topography of the open space, it's pretty steep slopes throughout. Do I think that would become an issue? Not necessarily. The woods roads are in pretty good shape right now, and I don't think a bike would really have much impact on that, but I think we would want to have the flexibility to adaptively manage the property under future conditions. So yeah, that would give us the ability to post against that.
And the question about dogs?
Yeah, I mean, we're not posting against dogs at this point in time, but again, if it becomes a point where the property is being abused or unrespected, I think we would want to be able to reserve that right to do so.
Thank you.
Thank you.
I think you could post to allow dogs, because if not, you're going to have a dog park, because we're experiencing that on our piece of property
Yeah.
that New Hampshire Audubon now has. It's the Quox property. This was almost 60 acres. And you can have a dog as long as it's on a leash, because we've had many people, and we're starting to have problems, it's turning into a dog park. So I would really request that. Camping, I'm not in favor for at all. If you say that the hunting is in such close proximity to the 300-foot buffer for safety, then camping would be detrimental. Our sign states that there's no collecting, no loitering. In other words, they can't go sit there and have a picnic and spend hours, because you're going to disturb nature and you're going to disturb the neighbors. Dogs on leashes, no bicycles. I forget.
Well,
what
he just said he's not objecting to bicycles.
What
If they
about
don't damage the property, then you have to reserve the right to post it.
What about snowmobiling?
Yeah, no unauthorized motorized vehicle use. So at this point in time, I don't see snowmobiles as an appropriate use of the property, given the size and the trail locations and lack of
Cross-country skiing?
connectivity. Yeah, sure, cross-country skiing, hiking, birding.
Snowshoeing.
You know.
And what's the allowed uses shall be permitted? That was what again? Just what we just went over, basically?
Yeah, you're essentially restricting development rights, but allowing forestry, agriculture, passive recreation.
Okay, and you mentioned community gardens?
I just, as an example, for the lease, you know, if we were to one day in the future want to lease, say, the top of the hill, there's actually really good agricultural soils up there. So if someone wanted to keep it in hayfield or something like that, we would have the ability to do that.
Have to drill it well.
Yeah, I'm not saying it's feasible, you know.
But you're not talking about people going up and digging it up and planting tomatoes and stuff like that?
We're not disallowing that at this point in time. When we take ownership of properties in perpetuity, you know, theoretically forever, we think it's wise to leave flexibility, and, you know, 99% of the conservation easements and conservation lands that we own allow for working landscapes, including agriculture or forestry.
You know, I can see haying and stuff like that, but when you start with just individuals coming in and having their plot, you don't know what chemicals you're gonna use, you know, how, you know, you've got the erosion and
Yeah, it's not a
also.
guaranteed right, it would be
It's a
under
hike
our
up there,
permission.
I walked up there, I walked up there, we've been there. Really have to,
Okay, Joe, Rose, you have anything else?
I don't think it's gonna really be.
What do you mean by non-commercial outdoor recreational use of the property?
So in other words, we couldn't sell tickets lift tickets for someone to go cross-country skiing on the property. It's not a commercial recreation.
Are you gonna allow like ultimate frisbee or things like that?
It's not technically restricted, but I don't think, as an ultimate Frisbee player myself,
Okay.
I wouldn't be using the property for that use.
All right, I mean, I'm just, you know, because the neighbors around there deserve the peace and quiet, and it's kind of sad that they can't hunt, because I know a lot of people.
Well, all right, is there any of the abutters have anything to say now that they've heard some more?
I have a question.
Okay, could you please come up to the microphone and
Okay.
name, rank, and serial number?
Lauren Andresen, Lot 24-2. Mr. Bialis?
What is lot
What's your
24-2?
address? It's in a butter.
Yeah, what is
Can you
that?
show us
your
your
address?
I mean, what's the address, I guess, is it?
39 Sanborn Drive, Newfields, but it abuts into Newmarket as well.
Okay.
We're
Okay.
here. This is the subdivision.
Yep.
So, Mr. Bialis, you talked about you're going to use the existing trail network?
Mostly,
And is this what's highlighted on this here? Can you show me what the trail network looks like? Because I'm a little concerned because our property is right here, and there's a very low stone wall that's broken down, so people could easily, we would see them biking and laughing and talking and snowshoeing and everything. That would be pretty, we're out there a lot. We're heavily out there. So could you just show me on this map where the trails are?
Yeah, sure.
Thanks.
So, and I can show
Yes.
the audience and then the
Yeah.
planning board. So the open space that we're talking about is this section here. Okay, the portion here is being retained by the landowner who sold the rest of the land for development. So when I say existing trail network, that's shown on this open space area in these white dashed lines here, and here. Our access to the property is off the end of the cul-de-sac. We will be constructing some sort of trail connector so that you can get from the end of the cul-de-sac to the existing trail. We anticipate we'll probably close off this trail because it's a pretty steep slope and it leads to land that is not ours, and that we don't have the right to travel over. So really, what we're going to be looking at is a trail that goes from the cul-de-sac here and then up to the top, and that's it. We may close this off, we may close this off,
Okay.
and we may close that off.
Thank you.
Yeah. Does the planning board want to see that as well?
Sure.
Yeah.
So, just to summarize, open space area here, the entrance to the open space is off the end of the cul-de-sac, so the existing trails are shown in the dashed white lines. We anticipate we'll close this trail off due to the steep slopes and the fact that it leads to a budding private property. We'll create a trail from the end of the cul-de-sac, somewhere in here, either straight or, going with the gradient, and then we may close this trail off and this trail off as well. So essentially, people will be able to walk into the property, do a little bit of a short circuit, and if they want to make it all the way to the summit, there'll be a small loop trail, as shown here on the summit.
Thank you.
Great, thank you.
Okay, one last time. Anybody have any questions? Come on up.
Question? Might be for the developer, and maybe it's just my confusion, but I think, is it 75 feet between somebody's property, like that a building can be? Is that what it is? Like these lines right here, I'm assuming, is
Setbacks
75
around the
feet from
perimeter?
our property? This right here?
No, that's,
We're here. And my question is as for the open space, is there any amount of footage where maybe like they can't tear all the trees down or anything like that up into our property?
Oh,
In
as a
open
buffer?
space?
No, I think they have, the management they have a right to manage it, but
Clear cut.
I don't think they plan to go out there and clear cut the property.
Are you
They're a
referring,
land conservation.
are you referring to the open space or lots that are being
Well, yeah,
developed?
because I wasn't sure, because I had read that there's a 75-foot maybe buffer,
It's a setback.
but it might be for a building, so I wasn't
Right.
sure if that could be also with the open space, like how much can you just clear cut all the way to the edge of the property, or is there a buffer zone there in the open space? So
Matt, can you show the board what is being
Yeah.
referred to?
I'm not quite sure, but
I think it's a building
I
setback.
think there's a rear yard setback. I don't remember what it is.
It is a big buffer on the open space plan.
But
75 feet, but I'm not sure if
That's
it's
a
a
rear yard?
buffer or a setback, and I want to confirm that in the ordinance.
there's your parcel's here,
Mhm.
so you're abutting 2 house lots.
Right.
And conservation land.
right,
Typically, in our subdivisions, people like to have woods in their backyard, so
yeah.
I would expect that there would be woods in those backyards.
Could you show us,
Can we
Matt?
see that
Can we
map?
see
Yeah,
what
please.
you're talking about? Yeah.
Our neighbor here, she lives in this parcel here,
Okay.
which is off the page.
Mhm.
And so these two, Lot 20 and Lot 19, 19 not really, a corner of it would share
Yeah.
property corner.
And then the rest of it is open space, so we have 300
This is open
feet of
space.
open space. So I
You're
was
referring to the
worried-
75-foot setback.
It's a
Yeah.
building setback,
Building
it's not a
setback.
buffer.
Yeah, I think it's a building setback, and I think it is
Yeah.
what they call rear yard setback.
Yeah.
Right.
Right.
So again, I just
there
wasn't
any
sure if there could be a buffer from the open space to somebody's property.
Were there any conditions of approval relative to that?
I don't think so.
No.
We just bought this in December, so we didn't know.
Yeah, no, I think the answer to your question, honestly, is that they could, Southeast Land Trust could go in and clear cut.
No, this is the developer.
Oh, those lot owners.
No,
Yeah.
well, I was just saying, I wasn't sure with the houses or with the open space.
Oh, it's the house lots, I believe it's a building setback, so they could clear cut their backyard if they wanted a big
Good.
backyard.
Yeah, I'm more, I guess I'm more concerned about the open space portion of it,
The open
but,
space being this piece here. 'Cause it's-
Yeah, so
The answer is what's intended to be open space and
Yeah.
woodland, so.
it's intended to be woodland, it's not intended to be
woodland.
clear cut.
Right.
But there is no guarantee that it won't be clear cut at some point.
But it's highly-
There's no intention, it's highly unlikely,
Highly
but
unlikely
there's
that the land
no
trust would
guarantee.
encourage that or advocate for that.
Yeah, and
Right.
just to speak to your concern, I mean, as a land conservation organization, we want to be good neighbors, otherwise people wouldn't support the work that we do. So it's not something that I would remotely imagine that we would be doing. So that
well,
makes you more
no, I mean, I
knowledgeable.
know she mentioned that, there's gonna be people now, and I feel like we're gonna have that too, because we can see the top. And so if it's clear cut up top, and then we can see right up there, that then there's gonna be all these people. So it's not just, creating bike paths and having this space for all these people to come, that now we're gonna be seeing them.
If it
So-
were to be clear cut, yeah.
Well, even if the top was clear cut, we could still see them. So anyway,
Yeah,
that was
that's-
just,
That's something that could happen.
yeah.
Do I have a related question then? Is there a mechanism that the trust has in terms of when decisions are made about, allowing dogs on leash, off leash, allowing or not, clear cutting or not clearing on the top, or, having a community garden? I know that's not something you're planning right now, but in terms of involving the local neighbors in kind of talking about those possibilities?
I mean, so we don't have any formal policy or procedure on that. I mean, obviously, as a good neighbor and a good partner in conservation, you know, we're willing to listen to the community, but there isn't any formalized process for that.
So, yeah, so I would just ask then informally if, in terms of the being a good neighbor part, if there are going to be kind of changes that you think might impact of reaching out prior to enacting those changes so that they have the opportunity to communicate about it.
Yeah, that's fine, and, you know, I'll give you my contact information before we go, and I'm sure Phil Ogier, our land manager, would be happy to walk the site with you and talk about your concerns with our planning management activities, so.
Thanks.
Yep.
Okay, does anybody have any other comments, questions? Nobody in the public? Oh, another question? Come on, will you please come up and...
I'll just state, Al Mitchell is part of the Mitchell Realty Trust, which we're substantial about it to this open there. We're thrilled that this is happening, or at least I am, so no problem.
Thank you.
I just need to state, so I live at Newmarket Mills, which is owned by Chinburg, so I don't see any, that influencing me in any way in terms of a vote on
that's
this.
not conflict.
Right, but if anyone does feel that there's a perception,
No.
I'm pretty happy to recuse myself.
There's no conflict for you on that.
You're not getting a discount on your rent for being on the
That wasn't part of the
Does-
deal, was it?
If there's no more questions, anybody in the public, one last time, no questions? Drew, thank you. Thank you,
Thank you.
David.
I do have an answer to, someone had asked how far is it from the houses to the top of the hill? It's roughly 750 feet,
Yeah.
based on scaling from the
It's
plan.
quite a
Thank you.
ways.
Everybody's read this, is there a motion?
I make a motion to approve the management plan for the open space related to the Hayden Family Revocable Trust, Mark Allen, Karen S. Hayden trustees, and Chinburg Builders, Inc., relative to the subdivision of special use permit at 74 Bald Hill Road, tax map R7, R24, R1, as presented by Chinburg Development LLC tract, Bald Hill Road, Newmarket, New Hampshire.
Is there a second?
Second it.
Motion's made and seconded.
Dated 4/8/2015. For the record.
Second it.
Seconded, we second, okay. Is there any further discussion? Comments, questions, concerns? Hearing none, all in favor, say aye.
Aye.
All those opposed, say nay. The ayes have it, 7-0. Thank you, everyone, for your input. Good luck. Thank you, Drew.
Thank you very much.
All right. Item number 5, new old business. Anybody have any new business? Does anybody have any old business? Oh, excuse me, could you, hey, can you guys take it, please?
Take it outside.
Thank you. We gotta hurry up, get out of here. Any old, new business?
Just about the planning board appointment to the CIP.
Oh, we need to do appointments to the committees. Do you want to do that tonight, or do you want to hold off until the next meeting?
What's
Do
the,
it quickly.
what's the member, okay, let's do it
I
tonight.
think Roseanne
He said one has to be
wants to
done
get
right
her.
away.
Last year, I was on the CIP
Right.
committee, and Joan was.
Yeah.
But I was just an appointed, now an elected official, and now you can only have one planning board member on the CIP. I can be a backup, an alternative, or vice versa. But I was the chair, and I had a lot of fun, and I liked it.
Jane, do you want to be on the CIP again?
I think I've been dethroned, so I'm fine with that.
And since, are they meeting already or starting to?
Well, I had planned on keeping the meetings going. We were going to do a lot of preliminary work before CIP work started.
You can appoint.
Yeah, so Rosie, you want to be on the CIP?
Yes.
Does anybody object to Rosie being on the
Jamie,
CIP?
yeah.
You appoint.
No,
Yeah, I
I'm
know,
probably
but
gonna
I do
cry
it.
all night, but I'll be okay.
Rosie, you're on the CIP.
Thank you.
Jane, you're the alternate to CIP?
Sure, I'll be happy to serve as an alternate.
What else do we have to do?
You can do the others next week if you
Conservation
want,
Commission.
unless someone knows what they want, you know.
Yeah, Conservation Commission? Does anybody want to volunteer for the Conservation Commission?
So John's gone.
Done it.
John's
John
gone.
is gone, Val's already
Ezra, do you
done
want to
it.
do the
Anybody
Conservation
else?
Commission? They meet
Members?
Third Thursday?
Thursdays,
Third
third Thursday of the
Thursday
month?
of the month.
Well, I was just looking at that, EDC.
Do you want to do that again, Val? Okay, good, you're in. What else do we have?
At 7? When do they
At
meet?
7.
At 7?
7,
Yeah.
yeah.
Um,
Advisory Heritage really is not for you.
I could do that.
Do that.
Yeah? You want to do that, Ezra?
Sure.
I think that'd be good for you. You'll learn
A little
the
more about the
conservation end of
community and
of it.
stuff, yeah.
So- Yeah, yeah.
They're great.
Okay, Ezra, you're on the Concom.
Okay,
That's
we-
it.
We continue to look for a Stratford Regional Planning Commission
Ugh, yeah.
I thought, was
representative.
Peter doing that with you?
I was doing it, and I haven't been.
Oh, but after you left, I thought maybe Peter was doing it, wasn't he?
Do you go to all those meetings?
No.
No.
I go to the TAC meetings for the transportation.
Okay.
Maybe that's
10-year
what I
plan.
thought.
Let's talk about that. You know, everybody's on stuff. Well, if Peter wants, maybe Peter will want to do it,
Okay.
right? Okay. Anything else? Any new old business?
I have something. I just wanted to remind everyone that the Community Visioning Forum is this Saturday,
Newmarket Live.
April 18th, Newmarket Alive. And I have some flyers here if you'd like to give them to your neighbors to get the word out to people. We've had 20 people sign up thus far.
Wow.
That's
And
great.
we'd like
Did
to
you
have
post them
more.
at-
For
Did
Saturday.
you post them around town?
Sue went downtown today and she put some flyers out in the stores and businesses.
Oh, good,
Is
good.
it- What time is that?
It's at 9 o'clock.
9 to 12
Till
at the town hall.
12 at the town hall in the auditorium, and refreshments will be served.
Just explain
And-
to the public, Diane, what it's about.
Okay. As part of our responsibilities under the master plan RSAs, we have to have a vision statement that sort of is the guiding document for our overall master plan, and especially for the future land use section, which we're going to be working on after this. And so what we want to do is have a visioning session. The Regional Planning Commission is going to help facilitate this process, and we'll be giving sort of an overview of existing conditions, and they have some different activities planned to help identify what the community feels are important issues for the next 10 years. And, you know, they've sort of identified 8 areas that it could address. And we're going to do like brainstorming sessions and then break up into smaller groups and have more focused discussions to really help to define where we are, where we want to go, and how we're going to get there in sort of conceptual terms. And that will be, they'll integrate all this information. We're also going to have a survey online, an interactive type survey that people can fill out so that we can try to draw from other people from the community that maybe can't make it on Saturday. And the Planning Commission is going to assimilate all this data and put it together for a second visioning session that's going to be held the end of the end of May. May 30th is the target date. We have to confirm that with a few people. And we'll be presenting those results and getting more feedback. And then they're going to put together a vision statement that this committee can review, this board can review and comment on, and hopefully adopt as part of the next step in our master plan update. And then there'll be sort of a segue into the future land use section that they're also working on.
Could you email me the link to the survey? Because they have a couple of groups that I can send it to their secretaries. and they
Okay.
can-
It's going to be right on the town's website.
Okay.
And I
usually
need to
take it
talk
and I
with.
download it to them, because.
Okay.
All right.
I'm going to work with Doug Poulin, our
It's on there
IT
now?
guy, to get, no.
All right.
It's supposed to be put up sometime, probably, I would say maybe Monday after
right.
the session, but it will be up there for a couple of weeks so that will give people an opportunity to participate if they can't make the meeting on Saturday.
Okay.
Just to emphasize this, I'm on this committee, it is very important for the public out there to participate in this. If you can't participate by coming to the forum on Saturday or the end of May, to help us. Surveys will also be available here at the town hall if you're not, getting them off of the computer. Because it's the vision statement within the master plan is really setting the precedent for the other chapters of the master plan, which then in fact culminate into zoning changes for the town.
What's important for the
So it is
town.
extremely important piece of the master plan, and, and it's something that just a handful of people and, citizens in the town should not be, we shouldn't be having a vision statement in the master plan that's only representative of, 25 to 100 people. It really should be a vision of what the majority of the people in this town are looking for.
Right, good point.
Very
Does
good
Steve
point,
put
Bill.
that in the newsletter? Did you have it, Dave?
Steve has put it in the newsletter that comes out every Friday. We also have it on the front page of the town's website. he put something up on the town's Facebook page, and we've also distributed the information to a number of organizations, and they're, putting it up on their web pages. So we're trying to get the word out. I have extra flyers if you want to pass them out to your friends, neighbors, see if we can drum up some interest. That would be great. I'll pass a few this way and a few this way.
I'll take a few.
I have no friends.
Mine are all an email.
All right,
I'll keep
anybody,
this one.
all right, any other
We hope
new or old
everyone can
business?
come. Will you be
Glad to be
able
back,
to? I know we have a few people that are out of town, have other commitments, but it would be nice to have a good core of planning board members there to
I'll give
help
an
lead the
EDC,
charge.
I'll give an EDC report at the next meeting,
Okay,
because we're,
Okay.
yep, we're pushing. And
finalizing
planners
that.
report, we'll do it the next meeting.
Yes,
You have
and
nothing to update us on,
just
right?
we got another email from the Office of Energy and Planning. They're looking to get the word out about their program that's coming up the first Saturday in May, which I think is May 3rd. I can't see. May 2nd? Second, May 2nd. And it's going to be in Concord, and we have money in the town planning budget to cover the cost of registrations and travel. And the sessions are very good, and I would highly encourage people to attend if they have the time to do it. It's
Is
well
anyone
worth
else
it.
on the board planning on
I'm
going?
planning to go.
Yeah.
Plan on going?
I'd like to go, I'm not sure what my schedule is gonna be. Are you gonna go?
I'd like to go, but I won't drive there, so
No,
if I
well,
can drive.
I'll call you. If
with
I'm gonna
someone.
go, I'll call you.
Yeah, maybe.
Well,
we
we'll
can-
talk. I'll
maybe
see
we
if what
can
my
have-
schedule is
okay.
or whatever.
Yeah.
You guys
We'll carpool.
coordinate
Yeah, I
and-
wouldn't mind doing that.
I can do it.
It's still open for reservations, so
Okay.
Yeah.
please do sign up. Registrations.
Okay.
And then I just wanted to mention, so I noticed in the proposal that we just talked about, it referred to one of the things as man-made, and I know that we also have chairman and vice chairman. I think that, I don't want to start a discussion tonight if there's objections, but I think that if we can use more gender-inclusive language, I think that would be a good thing for us, especially appealing to kind of younger demographic in Newmarket that is more used to that type of language. So just
that
something
is-
going forward
it's
of
a-
using like chairperson rather than chairman,
Okay.
or human-made rather than man-made.
Okay.
Well, I.
Yeah, fine. That's fine. We can talk about that. That's no big deal. All righty.
You gotta remember, this is New Hampshire, darling, live free or die. And we
You-
shall
and
use.
with what you were telling the
and we
developer?
shall use-
Janice, make a motion.
We shall
Second.
Second, all in favor?
Second.
Aye. All right, thank you.